Welcome to Looking at Legal Stuff. Today we have an evidentiary hearing in the case of a couple where Dad is asking the court to set aside the final divorce decree that he signed a few months prior because he says he was threatened and manipulated into their agreement. He says that not only did his ex withhold the children and make threats to move away or get him in trouble with his employer until he had signed, but she didn't even give him all the divorce paperwork, and he only ever saw the signature page when he did sign it. He says he tried to talk to the lawyer he had hired about the paperwork, but she disappeared on him for weeks, and he felt he had no choice but to sign it so he could see his children. He also says that the division of property in the final decree gives her all of their assets and leaves him with all of the debt, and in addition, she has him paying for everything in the final decree, including child support, spousal support, her mortgage, her utilities, her car payment, her car insurance, her cell phone, the children's cell phones, all of the children's homeschooling expenses, and all of the children's travel ball expenses, including 100% of the cost of her travel and hotels. He says Mom has him paying her more money than he makes in a month, and he's done his best to keep up, including selling his personal items, taking out loans, and borrowing from family, but he says he's too broke now to be able to keep on paying. What does Mom have to say about Dad's accusations? Let's find out.
Well, one of the issues that I want to address with the parties, or at least find out what your position is. This is a matter where, by my review of the file, is that there was an agreed marital dissolution agreement and parenting plan that was signed by this court and attached to the final decree. Subsequent to that, Ms. Duke filed a Rule 60 motion to set aside that final decree and parenting plan and marital dissolution agreement. And to my knowledge, has that ever been heard?
No, that's what we were hearing today.
Well, the docket simply shows it's a motion to compel and for sanctions and a motion for criminal contempt. But you're saying your motion for Rule 60 relief has been set for today as well?
Yes, it was my notice resetting. My notice reset this motion for today.
What?
Because I understood that to be the case as well. It was on my part, where to pay and cover issues, and then Ms. Duke was going to.
Well, the reason I ask is obviously if the court finds that there is a valid reason to set aside the final decree, then the motion for contempt over violation of the provisions of that final decree would be a moot point. So we'll take that Rule 60 motion up first. You wish to make an opening statement, Ms. Duke, or put on your proof?
I do, Judge, if you'll let me get my paperwork together. Judge, we're before this court on two different sides of this Rule 60 motion to vacate the judgment, one of which is whether or not the final decree, which included the marital dissolution agreement and the parenting plan, were equitable. This court is saddled with the burden of making sure that when a marital dissolution agreement is entered, and the parties have agreed to it, is equitable in nature. First and foremost, I would submit to the court that there is absolutely no way that this marital dissolution agreement is equitable. And I will go through the reasons why, but then we back up into the Rule 60.02 motion to vacate the judgment, which relies on fraud, misrepresentation, mistake, and inadvertence. Specifically, the court's going to hear testimony about Mr. Dunham being given information by the wife regarding what he was signing. There's going to be information that the wife said represented that she's not going to hold him to all these things. She's not going to make him, she was going to withhold visitation of their children until he signed these documents. It's inducing him to sign it. The things surrounding the circumstances of him signing this document would in and of itself show this court that the entry of it was fraudulent. Him signing it, her signing it, her representations to him were fraudulent. So we're asking the court on that basis to set it aside. In outlining the issues here, the court's going to see that Mr. Dunham was in the marital dissolution agreement, was saddled with the mortgage that was $2,300 a month, spousal support at almost $1,800 per month, utilities at the marital residence of $350 per month. That's an approximation up and down depending on whether or not they're using their heat and air conditioning. The wife's cell phone bill and the children's cell phone bill of $360 per month. He was saddled with the expense of all the kids' travel ball expenses, which in and of itself, looking at it from the outside, wouldn't have necessarily been inequitable, but he was also saddled with the gate expenses for entry into the travel ball tournaments for the wife. He was saddled with the wife's hotel expenses, which can accrue quickly when you're in a travel ball season. He was saddled with the expenses of homeschool. The travel ball expenses broken down over a yearly basis would range between $200 to $300 per month. He was saddled with homeschool expenses, which were $208 per month broken down. It's $2,500 per year. He was saddled with the wife's car insurance, which is approximately $100 a month. And he was expected to pay child support in the amount of $1,460 a month. That is equivalent to $6,766.16 per month. His monthly average income ranges between $6,362, which is $400 less than the amount he owes the wife, to approximately $7,500 per month. So he's hitting about the $6,800 a month range for income, and that's gross. That's before her health insurance is taken out. That's before the kids' health insurance is taken out of his paycheck. So when the court's looking at this, he doesn't have $10 to spend to put a roof over his head every month. So the marital dissolution agreement is not equitable in any form or fashion, and it absolutely saddles him with every expense of the marriage, and it has him responsible for paying all the debt from the marriage. There is significant debt in the marriage, and he's responsible for paying all those, which is not included in the monthly amounts because frankly, he's not able to pay those right now. So we're asking the court just to look at this from an equity standpoint and set it aside on that basis, or for the court to look at the circumstances surrounding his going to the UPS store and signing the signature page, but not getting to look at the document. That's our position, Judge.
All right. Mr. Hawley, you wish to make an opening statement?
I do, Judge. Take issue with several of the things that Ms. Dookie just said. First of all, though, the Rule 60.02, set aside, alter, amend, I don't think it's appropriate to set it aside. Part of what Rule 60 says is it has to be a reasonable time. Now, this was all done in November, is when he signed everything. And he's had ample time to come to court and follow Rule 60 until he filed it. Whenever he filed this thing, Judge, the evidence is going to show that he's started a new relationship, he's got a fiance, there's issues with the expenses and them planning whatever they're planning. But nonetheless, the reasonable time aspect of the 60 to set the whole thing aside is just not accurate. we take severe issue with the way that Ms. Duke says that, and is going to portray that this was executed by the parties. Mr. Dunham had this ample time. Mr. Dunham had a lawyer at the time. If you go back through and look at the file, he had retained, and we had started out in a contested arena with this, he had retained Ms. Roberts, one of the most experienced and well-known divorce lawyers in our jurisdiction. And he had, during this time, sent Ms. Roberts, it puts me in a little bit of an issue, but he sent Ms. Roberts a termination letter, which is going to be introduced into evidence today, basically saying that he didn't need her help any further and that he had already made up his mind what he wanted to do. You can read his own words when I introduce it. And, he wanted to sign, we'd come to an agreement, and he wants to sign this thing. From dealing with this, that was, you can look at the date of the letter. Ms. Roberts didn't necessarily get off of his case, I don't think, until it was about December the 7th is when she had previously filed motion to do visitation, temporary support, temporary motions, things of that nature. And that's when she withdrew. So there was a kind of an extended period of time in there that they were talking about it, thinking about it. I can only imagine what Ms. Roberts was telling him about making an agreement. She wanted to look at it, all of those things, but he wasn't having any of that. He sent her that termination letter, demanded that we reach the agreement that we reached, and was wanting me to do the paperwork. That's when my office says, I can't talk to you, you've got a lawyer. And then he figured out, do the termination letter, and that's what he did. So when that happened, he sent me a copy of that. We did the MDA, he got a copy of the MDA, and they met. The testimony is going to be at a place before that. He actually requested a change or two to it, and she came to my office made the changes, and I would not let him, as most lawyers, sign it in my office. My standard protocol, as it is with most lawyers, Your Honor did this for years, I let my client sign everything down there, but as far as the other side goes, you need to go somewhere else and have it notarized. That's proof that I wasn't anywhere around and had anything to unduly influence anybody to sign anything. So they met down at the UPS store, and that's where it got signed and got notarized and whatnot. So there was nothing unfair about the execution of this agreement in any manner whatsoever. This was totally his choice. He's a railroad worker. The testimony is going to be he's an engineer for the railroad. The pay stub's going to show, and the proof's going to be from Ms. Dunham. He well makes in the $90,000 range on a yearly basis. That was before a rather large raise that he got back when the parties were having issues and had kind of gotten separated. He got quite the raise beyond that. He's taking FMLA and a lot of time off from work to get the pay stubs down to where they are today, I think. But his previous salary and when he was married to her was more than accommodating for this. There's another big issue, the court will hear this, he's saddled with all of these things. Well, he's saddled with the mortgage and the utilities and the taxes on the property. And if you look at the MDA, it's in two different places. But in the other place, it says that the wife's responsible for making out of the spousal support to her the mortgage, the utilities, the taxes. And that's what she had been doing. In fact, when he stopped, and you'll see there's a little, well, I'm going to pay what I'm supposed to pay, and then I'm going to pay, I think, $750 for a couple of months. Now he's down to paying her only $500 a month. She got quite behind on the mortgage. She had, and the testimony is going to be, sell some of her own property to get the mortgage caught up. And it is caught up, as of today. So to sit there and say that he has that plus spousal support is unfair because he doesn't. Ms. Dunham was the economically disadvantaged spouse in this situation. The court's going to hear that she was unemployed, homemaker. She taught the kids, homeschooled them through a curricular program, and was there every day doing that. And that's what the parties had set up, and that was the way that they had arranged for the kids to be treated on a day-to-day basis with their schooling and whatnot, and that was her responsibility. So she didn't work. If they weren't going to be homeless, all that had to happen. So sit here and say that, yeah, spousal support plus mortgage and everything, that's not the case. Ms. Dunham very conscientiously used the spousal support to make all of those necessary payments to keep the boat afloat here, until the kids can get a little older, she can get a job, start figuring some things out or whatnot. So that was all by choice. And he had the choice, you know, that day not to sign it and to turn away, but he did not. He went and reviewed everything. He had the documents, he reviewed them. He asked for a change, the changes were made, and that's when he agreed to all that and signed it. You know, for that to be some sort of issue as to set this thing totally aside, you know, we disagree with that. The child support's ran per the guidelines. There's no upward or downward deviation. That is what it is. And the spousal support is more than appropriate for the mortgage, utilities, taxes, and the expenses and the day-to-day curriculum that these young men these young children were going through, you know, to take on the livelihood of the children and Ms. Dunham. So all those funds were necessary. You'll see text messages where he agreed to that. He wanted that to happen. He wanted to support the children, you know, and all of those things. So I think what the court's going to find today in closing, he's got buyer's remorse. He's got a fiance. They've already taken I know they're taking one vacation, let me put it that way, together with the children, somewhat we'd say in violation of the Section J of the parenting plan, but he's already done that. And my understanding is it's a fiance situation and, you know, it's where he's wanting to move on, but he needs to take care of his obligation here with his first wife and his children, you know, before he does choose to do that. And these finances that apparently Mr. Dunham was, quote, saddled with were more than appropriate and just basically to keep the party's lifestyle the way that it was.
All right. Ms. Duke, you may call your first witness.
Judge, I'd call Mr. Dunham.
Mr. Dunham, if you'll come around here to the witness stand, raise your right hand and be placed under oath. Have a seat.
If you would, please state your full name for the record.
Michael Gregory Dunham.
And Mr. Dunham, you were married to Miss Dunham,
Yes.
and did the two of you go through a divorce back in, the divorce was finalized in March, is that correct, of 2024?
Yes.
Okay. And in November, did you sign a marital dissolution agreement?
Yes.
Prior to signing the marital dissolution agreement, did you have the opportunity to review the marital dissolution agreement?
No.
Okay. When you were presented with the signature page to sign, was that the only page that you saw?
Yes.
Okay. And what had Miss Dunham used in order to get you to sign that?
She just said that I couldn't see the documents because they're at her lawyer's office, and she just said she told me what was in it and stuff, and she just said I just needed to sign it, or she was going to not let me see my kids.
Okay. And so did
Pull that
she,
microphone towards you a little bit there.
so did she use your children to have you sign this document?
Yes.
Okay. Did you get to see them after you signed it?
Yes.
Okay. How long had it been since you saw them when you actually, after you signed it?
It had been about 3 weeks, 2 to 3 weeks.
Now, in that final decree of divorce, let's address a few of the statements that Mr. Hawley made first, just so that we get that cleared up.
Okay.
When you signed this and realized that you could not make ends meet in order to handle the expenses that that you were given in the final decree and marital dissolution agreement and parenting plan, did you start working towards finding money in order to hire a lawyer?
Yes, I pretty much sold all the valuable things that I have, and my mom ended up having to pay for the lawyer for me. And I did have another lawyer, Miss Roberts, but as he was saying, she had an illness. Her mom was ill for like 3 weeks. I could never get a hold of her. And
Is that when you couldn't get in touch with her, is that when you tried to handle the divorce on your own?
yeah, and I actually went through Miss Dunham too to try to, because I'm not real savvy when it comes to this stuff. So I even asked her what I should do.
Okay. And you don't necessarily fault Miss Roberts. Her mother was ill, is that
No,
correct?
no, I don't.
But at that time, because of her mother's illness, were you able to get into court to get your visitation set or anything like that?
I wasn't able to do anything. And the reason why I sent the termination letter is because in the middle of all that, Miss Dunham broke into where I was staying and took all my valuables, about $20,000 worth of stuff. And then I just gave up. I thought, I don't have a chance. I just said, I said, Mr. Robert, I don't need your help no more. Once she called me after that happened a few days later, and I'd already signed the papers. And at the UPS store, I just said, I'll just sign them. But I didn't think I had any help.
Okay. And in that paperwork, well, let's do something else. Mr. Holly alleged that now all of a sudden you've decided to take FMLA and you've lowered your income so that you can't cover this. When did you start using your FMLA?
2014.
Okay, is it based on a disability?
Yeah, well, I've got high blood pressure, and with my job, it's pretty stressful sometimes driving a train, and so my blood pressure goes up, so I have to keep an eye on it.
Are we
So I
referring by FMLA to the Family Leave Act?
Family Medical
Yes,
Leave
sir.
Act, yes, Your Honor.
And then in 2019, before I became an engineer full time, I was a conductor, and I hurt my arm real bad, and I was out of work for 5 months, 4 or 5 months, because I had to go through physical therapy. So I got it for that too. A lot of times my arm's messed up.
Do your arms stop working where that you actually cannot physically do your job?
It did sometimes, yeah.
And were you approved for FMLA?
Yes, ma'am.
Okay. Did Miss Dunham encourage you to go through with the FMLA process?
She's the one that told me to get it.
Okay. And have you been approved as late as the onset of your condition was back in 2014? Is that correct?
Yeah.
All right. Holly says that all of a sudden you've decided you can't pay these things because you have a significant other. That's not accurate, is it?
No, because that just happened in August. This has been going on for almost 2 years, about a year and a half.
So, if I may, Judge Approach.
You may.
FMLA paperwork.
Yes, ma'am.
Okay. And does it confirm that you've got issues with using your arms?
Yes.
Testifies to what his problems are. That doctor.
The objection is to the hearsay of this document.
Judge, he can have it entered as having received it as his document. It can be used for identification purposes also. It's not hearsay for that purpose.
Well, I'm going to allow it over the objection because if it is in fact some sort of confirmation of the fact that what he's testified to, that he is receiving family medical leave and has been approved for it, then I'm going to allow it to be introduced for confirmation of his testimony or corroboration. But I will accept it for that limited purpose only. Overrule the objection.
Judge, I'd submit that as the first marked exhibit.
Mark it as Exhibit 1.
Throughout your marriage, did you use FMLA regularly?
Yes.
Okay, and was that ever an issue with Miss Dunham throughout the marriage?
No.
Okay, and now is this the first time you're hearing that it was an issue?
Yeah.
Okay. In the final decree of divorce, which kind of speaks for itself, but we're going to go through the issues that are in it, was Miss Dunham awarded the marital residence and all the equity?
Yes.
Okay, and how much equity approximately was in your home at the time?
$170,000.
Okay, and did you get any portion of the equity of that marital residence?
No.
Okay. Were you required to continue paying the mortgage until she refinanced or your kids aged out?
Yes.
And the mortgage is how much per month?
$23.37.
Okay,
I'm sorry,
and
how much?
$2,337.
Thank you.
You're welcome.
you heard Mr. Hawley say that you all of a sudden are not, that you make upwards of $90,000 a year, and now all of a sudden that you're not making that. Was it a surprise to you that he said 90?
Yeah, because the divorce decree says 120,000.
And at any point in time, have you made $120,000?
I've only made 100,000 one year.
Okay,
And that was-
and so was that a misrepresentation to the court by Ms. Dunham?
Yes.
The most you've ever made was in 2023, is that correct?
Yes, ma'am.
Okay, has your salary over the year kind of gone up and come back down?
Yeah, it's about 80,000 on average.
Okay. Were you also required to pay her $1,787.50 in spousal support per month?
The total is 3,000 a month. Yeah. 1,700. Yeah.
And were you required to pay all of the utilities at the marital residence?
Yes.
Do those average out to be about $350 a month?
Yes.
Were you required to pay the cell phone bill for your children and for your wife?
Yes.
How much is that bill per month?
360.
Okay. And do your kiddos play travel ball?
Yes.
Okay, and as a part of playing travel ball, I can assume that there is an expense to pay the travel ball team.
Mm-hmm. Dues.
Is there an expense for uniforms?
Yeah. Equipment.
Are there gate fees that you've got to pay
Yes.
when you go to tournaments?
Yes.
And are you going to tournaments regularly with these kids?
Yes.
Did the marital dissolution agreement also require?
Yes.
In your mind, does that total up to be upwards of $2,400 a year?
Yes.
Sustained, don't leave the witness.
I was just trying to get through it quickly. We've got our list here. Tell me about how much you're spending on that per year.
About $2,400.
Okay. And are these kids currently homeschooled?
Yes.
Okay. Well, are they in homeschool?
Yeah.
Does she actively make them do homeschool?
I don't think she does because they can barely read and write and they're 12 years old. They're going to be 12.
How much is homeschooling per year for the both of them together?
About $2,500
Okay. Per year?
per year, yes.
Okay, and that's $208 a month. Is that fair?
Yes.
How much are you paying for her car insurance per month?
About $95.
Okay. And how much is your child support? Is it $1,460 a month?
Yes.
Okay. Judge, if I may approach,
May.
break down an accurate how much you were paying per month for your wife's expenses. Is there anything I've left off that you can think of?
What's the basis of your objection?
So she,
No, we've created that document for today. It's just like an income and expense statement.
Well, it's just, I mean, routinely in court, we utilize documents that are reflecting and interpreting what the parties say. And a perfect example is the income and expense statement, which technically could be hearsay, but is also used to allow the parties to testify and have some document that helps the court to understand it. Overrule the objection. It's not being admitted to prove the truth of the matter, but rather to reflect what his testimony is.
Is there anything on there that you can think of aside from your, are the debts you owe from the marital dissolution agreement requiring you to pay debts, are those actually included?
no.
Okay, how much are you paying towards those per month?
I had to quit paying them. I had to get a debt management because I couldn't pay them. I had to get a achieve debt management. I pay them like per month.
And how much are you paying per month for that?
I have to pay $400 a month, and then they disperse out to the debts.
Judge, if I may approach so that he can write that down.
Right?
Are you paying $400 in addition to $6,793 monthly to the wife?
Yes.
Wife retain all of the personal property as a result.
Yes.
Work is next in order.
Are you currently making at best between $6,500 and $7,500 per month?
Sustained.
I'll give him his pay stubs. I've got those. That's fine. How are you paid? How often are you paid?
Every 2 weeks.
Okay. I may approach him.
You may.
Copies of your pay stubs for the last couple of months. I don't know.
Yeah, 6 months.
And in those pay stubs, are you paid bi-weekly?
Yes.
What your current gross earnings are on what were your gross earnings for what were your state earnings for 2024?
$80,157.56.
Okay, and were those your gross?
Yes,
Okay. What were your net earnings?
$70,668.83.
And after you paid your wife,
No, my mom's been paying my rent.
that's,
Marcus is the next in order.
when Mr. Hawley said that in his opening that you intentionally are making less now, have there been periods of time in the last 5 or 6 years where your income has dipped down below 80 and then come back up?
Yes,
Is this a copy of your earnings each year?
yes, ma'am.
And if we could go through, for example, in 2020, what were your earnings?
$45,116.19.
Okay, and in 2019, what did you earn?
$94,731.47.
Okay, and in 2021, what did you earn?
$85,659.38.
In 2022, what did you
$77,388.90.
earn? Okay, and so by looking at this, is your income always going up from year to year?
No,
Judge, I'd submit this as
The Exhibit 4.
And in the final decree and MDA and child support worksheet, did Mr. Hawley have you written down as $120,000 a year?
yes,
Okay. In any of those monthly income totals, did you make $120,000 a year?
no,
Forgive me because I don't know the answer to this, but I do need to ask it. Are you having to pay for COBRA insurance for your wife? Or is she still on the family policy?
she's still on the family policy.
Okay. If the railroad changes it to COBRA insurance, would it be significantly more?
Yeah,
Okay. Do you know what your requirements are for switching it over to COBRA? Have you asked?
no,
In the marital dissolution, let's ask. Your wife, is she educated?
yes, she has a bachelor's degree.
Okay. And is she able to work outside the home?
Yes,
Okay. Are your children old enough to be left at home alone? How old are your children, sir?
they're 11 and 9.
Okay. And are you a proponent at this point in time of potentially public school based on the fact that they can't read?
Yes,
Were you a proponent at the time of the final entry of the final decree of getting them in public schools?
yes,
Pursuant to the final decree, and it's not written on that yellow sheet, so it'll be in addition to that, are you required to pay medical bills for the kids?
yes,
Okay, and that's okay, do you need a minute? Are you required, you're required to pay medical bills? Are you required to pay dental bills?
yes,
Okay. Has she been sending you medical and dental bills?
yes, whenever they need it.
does that number fluctuate so that you can't necessarily put an exact number on your monthly amount for that?
Yeah.
When was the last time you paid a medical bill that you can recall?
Probably been a couple months. They had a dental bill. It was
You-
$106, and then a medical bill.
Do you currently owe the Internal Revenue Service for debts acquired during the marriage?
Yes.
And how much, to your knowledge, do you currently owe the Internal Revenue Service?
$6,900, but it could be more because I haven't been able to get my taxes done because she won't give me the paper, my son's social security number. Asked her for it and she won't give it to me, so I can't even get my taxes done.
Okay, and have you requested, strike that, Judge? Has the wife manipulated you or done anything to make you feel badly in the eyes? Strike that. When you have communication with her about paying these bills, does she call you names?
Yeah.
Has she withheld your children when you are unable to pay her full amounts?
Yes.
Okay. When was the last time she did that?
We're dealing with a Rule 60 motion. How does this testimony relate to the issues in a Rule 60 motion?
It just goes towards fraud and misrepresentation. It's part of an ongoing withholding children in order to induce him to sign.
I would agree. Sustain the objection. It's not relevant to the issue before the court at the moment, so.
Okay, I'll move forward. Are you required to pay her car registration and stuff too, or is she taking care of that?
I did last time.
And what bills, if any, is she responsible for?
Nothing.
Now, when you say nothing, is she paying for food for the boys?
Yeah, with the money I send her, yeah.
Included in the utilities, are you paying the trash service bill?
Not anymore.
You able to pay the trash service bill?
No.
The November 7th. You receive text messages from her regarding signing the documents.
Yes.
Judge, if I may approach.
You may.
Had she taken your bank cards and credit cards from you?
She didn't take them, but she has a way to go into all my stuff with my emails and stuff, and she uses it that way.
Was she using your card at that
Those are baseball cards.
time? Okay. Did she take your card?
Yes.
Okay. On what date was that?
November 7th.
And what text message?
Oh, this one she broke into my place I was staying, and she took a gold, silver, cash. I collect a lot of baseball cards and sports cards, and I had about $15,000 worth of cards she took out from me whenever she was in there. So this when I filed a police report, the deputy come out there and he had to go get them from her. Carrie, you have 30 minutes to bring my cards back to me. I'm bringing the police to the house if you don't. Now you're stealing from me. My friend called me while I was at work and said, is there any way she should be at your place?
I don't quite understand. Are you reading me a text message between you and her?
Yeah, this is a text message I sent to her. I was telling her that I'd called the police and that she had I was going to call the police and she had 30 minutes to
What
bring me back.
portion of this is hearsay? All right. The objection is withdrawn.
Someone had told you that she was there and you were repeating that.
Yeah, my friend called me when I was at work and he said, is there any reason why she should be at your place? And I said, no. Says it right here.
Well, hearsay is a statement made out of court that's introduced to prove the truth of the matter asserted in the statement. Not every statement that's made is hearsay and excluded by the hearsay rule. It has to be as to what's the purpose in introducing it. What is the statement?
The purpose in introducing it is, you told me you were here. The only purpose in introducing it is, had this conversation with her to return the cards that she had taken.
Overrule the objection.
Now, what did she say to you? Just read that.
Michael, stop playing games.
And then what else did she say?
I've logged all our cards. If you sign the agreement that you already agreed to, it won't matter. But if you decide to change what you agreed to and waste thousands of dollars in court, the judge will see all your assets. I don't want to argue and fight, but I will not be manipulated anymore. The Lord knows what you're doing and will take care of me and the boys no matter your actions. I really hope you can start thinking about them before yourself.
And was she threatening you about the cards in this statement if you didn't sign the agreement?
Yeah, she was going to sell them.
What did she say there?
She always just says, all you do is lie. She calls me a liar over everything. You're just a liar.
November the 11th, had you stopped talking to her about the agreement?
Yes.
Okay, and what did she text you?
He said, "You understand that refusing to even talk or look at the agreement and parenting plan is just wasting money, since the court will require mediation before anything, which through lawyers and a mediator will cost a lot of money. But just working it out costs only the filing fee and editing fees. Then if we go past mediation and get to court, all your lies will be exposed and the judge won't look favorably on you. I have piles and piles of evidence of your lies, and all the evidence can be backed up, even more with subpoenas for your FMLA days you mark off, personal days, vacation, everything. Then your work may open more investigations about your misuse of FMLA. And there is the possibility of the judge referring your illegal Jersey sales to investigators. Selling those to that store along with everyone else is highly illegal. I even showed you that guy who was arrested back when I was begging you not to sell them, begging you to stop. You agreed to stop and never did. Please think about just working things out and stopping your illegal behavior, along with other stuff you are doing. The boys need a godly dad and need you to think about them before yourself. Think through how your actions will affect them and their lives. They need stability and to not be brought into this like you have been doing. It will be harder to see them with your already bad schedule if me and the boys have to move away. They won't see their cousin Abe much as well. I don't know.
Don't
That's
go
a
to
different.
that one yet.
Okay.
So in this text message, go ahead, Judge.
All right.
On the agreement, she was threatening to have you investigated with your work through FMLA, and she was threatening to move away with the boys. Is that correct?
Yes, ma'am.
Okay. Are you a godly man?
Yes.
Okay. Has she tried to use that as a weapon in this case?
Yes.
Okay. And in this text message even, does she bring up godly man and take care of it?
She always does, yes.
Okay. Judge, I'd submit that as the next one. Judge, if I may have one moment, I've got to find another text message.
Well, let's take our mid-morning recess. It's 10:30.
Thank you, Judge.
We'll be in recess for 15 minutes.
All rise. All rise. This court's now back in session.
Judge, I'm going to be done with the text messages. I thought I could be if we
All right.
got done. I'm going to approach him quickly, and then I will be done. We're going to do parenting plan, go over it.
Mr. Holly, your client, Ms. Grammon, had entered the waiting room on that. You might want to let her know that it's been reset, so. Go ahead. I can send her a message on chat as well. All right. All right.
Yes.
Page 4 of your permanent parenting plan, in order to calculate child support, what number do they use?
$10,000.
And is that a misrepresentation of how much money you make?
Yes.
Have you ever, in the history of working for the railroad,
No.
that number, would you have had it corrected?
Yes.
Also required to maintain a life insurance policy.
Yes.
Okay, does that come out of your paycheck? Out
Uh,
of your gross paycheck numbers?
It's separate.
And are you having to pay that in addition to the expenses you've got listed on that?
Actually, it does come out of my check. I'm sorry.
Okay.
Yeah, 'cause
Does it come out of your gross amount on your paycheck?
Yes.
In paragraph 5 on page 3, bottom, the other expenses that you're required to pay, you're required to pay all equipment, school books, any and all extracurricular activities, homeschooling group fees, homeschooling tuition, travel baseball, and travel basketball.
Yes, ma'am.
Okay, and then going down to paragraph 6, it says that your children play travel ball and that you would pay all gate entry fees for the mother. Travel ball tournaments that are within an hour and a half away from the home, from the mother's marital residence, that you be required to pay for the hotel rooms for those tournaments. Is that correct?
Yes.
Okay, and is that upwards of $700 per tournament that you're having to pay?
Back to the leading judge.
How much are you having to pay for,
Sustain the objection.
hotel rooms?
They're about 250 a night.
Okay, and how many nights is she generally having to stay?
It's usually just the one night.
And are you having to pay those, how often during a baseball season?
Probably about five times.
Now, the mother has maintained until recently stating that she doesn't have an income, is that correct?
Yes.
And her income was imputed in this parenting plan, is that correct?
Yes.
Okay. Do you know why she would be claiming the minor children on taxes if she didn't have an income at the date of the entry of the parenting plan?
No.
Okay, was the mother given the ability to claim the minor children on income taxes when she did not have an income?
No.
Taken in burdens, why would she claim the children? And why would this parent have her claim the minor children if she did not have an income? Why would he sign that thinking that was appropriate? That's absolutely mistake, inadvertence, and fraud.
I mean, he did sign it, and.
Turn your microphone on. If you're going to stand up and object, just turn that microphone on so it makes sure it records.
Oh, there we go. The light was on. I'm sorry.
Now, go ahead.
Oh, well, again, we're into the issue of taxes in the parenting plan. I guess I'm objecting to the relevance because I don't see what that has to do in the formation of the MDA and the parenting plan when he did sign it. What any of this really has to do with the formation of it to fraud, inadvertence, excusable neglect, misrepresent, all of those things. It's a situation where he signed it. And we're where we're at today. But what does that have to do with the formation of the fraud, misrepresentation, excusable neglect, and misrepresentation on November the 7th or November the 13th when he signed it, I'm sure.
Part of the assertion here is that he was never provided the documents, that he signed the signature pages, and he's testified that he was not provided the documents, that he simply signed the signature pages based on representations made by the mother. My position on the tax credit is that had he actually seen that in the parenting plan, which is what he's testified to, he wouldn't have signed it because it makes no sense for her to claim 2 minor children when the parties have tax debt and she doesn't have an income.
I'm allowing the introduction of this testimony to, and for the basis of corroborating his testimony that he didn't see the agreement and only signed the last page. I'll accept it for whatever weight that has on that. So, overrule the objection.
Mr. Dunham, had you seen that she was claiming the minor children for income tax purposes when she didn't have an income, would you have had Mr. Hawley's office change that?
Yeah,
Okay. And at the time of the entry of these agreements, you actually had income tax debt, is that correct?
yes,
Which claiming the minor children would have helped with that debt, is that correct?
yes.
Aside from the $160 in equity in the marital residence that she had, did she also receipt about $30,000 in gold?
Yes,
Okay. In the division of the personal property, did she get to keep the your golf cart?
he kept everything, the golf cart, the trailer, the storage building, and now she sold it.
Okay. And has she recently sold some of those things while this is pending?
Yes, like about 3 or 4 weeks ago, she sold the storage building.
Okay. And in exchange for all of those things, what did you walk away from the marriage with?
Nothing.
Okay. Did you get to keep your baseball cards?
I did get to keep my baseball cards.
And how much are those worth?
Probably $30,000.
Okay. And so, going backwards, was she allowed 10 years to refinance the marital residence in the marital
That's
dissolution
what it
agreement
said,
also?
yes.
Okay. Is that inhibiting you from getting another place of your own?
Yeah,
Okay.
I couldn't pay for it anyway.
Okay. In your mind, is she able-bodied and capable of working, maybe even more so than you are?
Yes.
Okay. Judge, that's all.
Mr. Hawley?
Yes, sir. Not Mr. Dunham, I'm Reese Holly. I'll ask you a couple of questions about having a lawyer at the time that you saw the paperwork or at the time that you executed the paperwork, let's put it that way. You hired Ms. Roberts, correct?
Yes.
And at the time that you had signed this document on November the 13th of 2023, you remember that's the date that it was signed, correct?
Mm-hmm.
Is that a yes?
Yes,
Okay. So at the time you signed it, Ms. Roberts was representing you. Is that accurate?
yes.
So had you sent her a termination letter?
At the time that I signed it?
Had you already sent her the termination
No.
letter?
No.
Do you remember what date you sent her the termination letter?
I don't think I ever sent her a termination letter. She called me after I'd already signed it because of the stuff that I'd gone through with her taking my stuff. And I hadn't been able to get a hold of Miss Roberts for about 3 weeks because of the illness she had. And so when she finally did call me back after I left her message and about 3 or 4 messages, she finally called back. And when she did, I told her I didn't need her services no more because I already signed the paper because I couldn't get a hold of her.
Judge, if we may all approach just the have a discussion.
All right. Question you asked was he represented by Ms. Roberts at the time he signed the agreement? Depends on when. Ms. Roberts never made an appearance in this case, that issue. The complaint was filed November the 20th of 2023. There is nothing subsequent to that, no appearance by Ms. Roberts until the final decree was entered March 19th of 2024. There is no. Oh, she had a separate complaint?
And so if he.
Well, let's find out. Can you get me the file? There was another file that Ms. Roberts filed, Dunham versus Dunham. Let me review that file. Let's get that file and let me look at it. We're going to stand a recess till we get the other file that's being mentioned.
All rise.
Do we need to approach that?
No, I've reviewed the additional file that was in question, and for the record, will state that Ms. Roberts filed a complaint from Mr. Dunham for divorce on November the 13th of 2023, which was 7 days prior to the complaint filed by Mr. Holly. On that same day, she filed a proposed parenting plan, and then she filed a motion to adopt the proposed parenting plan on that same day as well, and set it for a hearing on the 7th day of December. Then she filed a notice of non-suit on, looks like that complaint was served on Ms. Cara Marie Dunn on November the 15th. But then there was a December the 7th notice of non-suit that Ms. Roberts filed. So the case that she was representing him on was concluded on December the 7th. Now, this marital dissolution agreement that we're at issue over appears to me to, according to this, who have been filed on November the 13th of 2023, which was prior to the dismissal of the case pending that Ms. Roberts had. And in fact, I think it was on the same day that she had set the notice of a hearing on. Now, the question of whether or not he had discharged her prior to that time with a notice of dismissal or a notice of termination is the issue that, I mean, it is and it isn't. If he says he's discharged her prior to that November 13th, then there's no real ethical issue. If he had not discharged her prior to signing that, then there could have been an ethical issue that would have to be investigated. So the question becomes, do we need to inquire of Ms. Roberts before we go any further as to what the date of termination, or does your client know offhand the date of his termination letter?
after it. Yeah,
Well, the issue is the service was on at the time.
No, but Mr. Holly said he was aware that Ms. Roberts was representing.
Oh, no, I never said that. When she got served was the first that, I know Ms. Dunham had heard of it, and then when she brought it by my office sometime later, was the first that I'd heard of it, and Ms. Roberts and I had several discussions about the whole thing. Well, that's what I'm saying. I know, it said the 15th is the date that Ms. Dunham got served, and he signed all this stuff on the 13th. We had no knowledge of Ms. Roberts' representation.
November 15th is the date of service of process, which is 2 days. I'm sorry, what?
I think Ms. Roberts had communication with Mr. Holly. We might want to check.
Well, let's take an early lunch and let you all investigate that, because it does become an issue, obviously, the validity of an agreement that was signed outside the presence of a lawyer that was representing without her knowledge and consent may very well be invalid on its face. So,
Well, may I?
sure.
She had noticed on the 15th, that was the first time that Ms. Roberts really made any sort of knowledge to Ms. Dunham that he was even represented at that point. We testifies to when she let my office know, but Ms. Dunham didn't know anything until the 15th.
No, there are text messages that say otherwise, right here. She knew, she communicated with him about Ms. Roberts, telling him to fire her.
I think he was telling everybody that he had a lawyer, and there's a lot of text messages that say, no, I don't want my lawyer to do this. I've reached an agreement and this is what I want to sign. But there was nothing filed by Ms. Roberts until the 15th.
But what's important is if you're the one that brought this up, if he had a lawyer at the time, it had to have gone through the lawyer.
I would agree. We're going to find out what the status of his lawyer was over the lunch hour, and see if you can contact Ms. Roberts and find that out, or be prepared to address that issue when we return from lunch. But if he had a lawyer, it is unethical and therefore would invalidate an agreement that was signed by him outside the presence of his lawyer. And that's just the issue. That's the whole purpose of having a lawyer and having the ethical obligation to only deal with that lawyer. So,
Well, if I may.
On November the 11th, he tells her.
on what day?
November the 11th, he tells her, okay, Heidi said the lawyer I got could do it. He tells her. He had a lawyer.
Well, but it's the notice situation. I mean, there wasn't anything filed by Ms. Roberts until the 15th. If he says he has a
It was filed
lawyer,
on the 13th, served on the 15th.
well, the notice is on the 15th as to when we got served, or Mrs. Dunham got served, rather, let's put it that way. That's the only time that she formally knew that there was a contested divorce in play. And a lot of times it's, people get lawyers to look over paperwork and do those types of things. And he could have taken that, my point is, on the 13th, if he had have retained Ms. Roberts, he could have taken that paperwork to her, but he didn't choose to do that. He chose to go down to the UPS store by himself and sign these documents without, and again, there's not been any filings by Ms. Roberts beyond, even on the 13th, but there's no notice until the 15th. So even
Right,
before that,
I have
think
the
it's-
factual basis that I understand what it is, and that the arguments that both of you are making, and I will consider that in my ultimate ruling. I would simply point out that this marital dissolution agreement that we're in contention about and the parenting plan were both signed on November the 13th of 2023. The complaint in this case that Mr. Holly filed was not filed until November the 20th of 2023, which was 7 days after the signing of those documents. So there was no pending case in this court other than the case that Ms. Roberts had filed on the 13th when those documents were signed. So,
and those
let's go
did just
forward.
cross in the mail.
Pardon?
For the most part, those were doing without Ms. Roberts or I, neither one really understanding what was going on with each of the parties. But that's part of my line of questioning with him, is when did he actually retain Ms. Roberts? What was his
I'm gonna let him question it. We'll deal with it in the ultimate.
Respectfully, Mr. Holly and I had a conversation. We were calling earlier about every everything he knew about Ms. Roberts. So it's disingenuous for him to get up before the court and say he didn't know Ms. Roberts was represented.
No, I did.
I call it like I see it, and I'm
Oh, at some point I
not gonna
did.
let an ethical obligation pass on this.
No, this is not unethical. Believe me, if it was, Ms. Roberts would have well raised it at that time because it was her client that was in the middle of this.
Her mother was dying. Like,
That is what Mr. Dunham has testified to, that he discharged Ms. Roberts because he could not reach her and contact her because her mother was in the hospital on her, essentially the last days.
But
Ms. Duke, I am aware of your contention regarding this. I will weigh those things when we make the ultimate decision in this case, but I'm going to allow Mr. Hawley to go forward with his line of questioning.
are we taking a break for lunch or go ahead?
No, I don't think there's any reason to break at noon or thereabouts. So. Mr. Hawley, you may continue.
so when did you retain Ms. Roberts?
3 weeks prior to signing the papers.
Okay, so 3 weeks.
Scoot up on, pull that microphone base towards you. You can, there you go.
All right.
So 3 weeks prior to.
I would say probably the 1st of November.
The time you signed these documents, you had an option, if you wanted to go and see Ms. Roberts. Is that correct?
I tried 3 times, and I tried to call. I left her messages, 2 or 3 messages. She never did call me back.
Okay. But rather than wait on Ms. Roberts to get back with you, or even go hire another lawyer, your option was to, with Ms. Dunham, sign these agreements, correct?
Yeah, because like I said, she broke in and took a lot of my stuff, a lot of my valuable stuff, and I just felt like I had no help. I had nowhere to turn. I didn't know who to talk to. When she took all my stuff, then a couple of days later, whenever she said, if you just sign these papers, so I did.
Well, again, you're telling me that you retained Ms. Roberts some 3 weeks before you actually signed these documents.
Yes.
And then again, at the time you signed these documents, it was your position that you were terminating Ms. Roberts and you were going to sign these documents for whatever reason.
I didn't know then. I just knew that I couldn't get a hold of her. And that's after that happened. The day later is whenever after she took my stuff, that's whenever I agreed to sign the papers.
Okay. And did you talk to Ms. Roberts at all after that?
She called me 3 days later.
And you're aware that you could have filed something to set aside the MDA or set aside the parenting plan based on your signing that with
didn't
knowledge
know.
of a lawyer? I mean, did she talk to you about that?
No, actually, she wrote out the paperwork, had all this stuff totally, had joint custody. She had all the stuff where I would get the house and I might be able to move in the house because I had been paying all the bills. She had all the stuff and the parenting was going to be even. And she had it all wrote out. She just, whenever her mom got sick, I guess, she just never did file the paperwork. And I kept on trying to figure out what was taking so long. So I tried to call her and I left messages and couldn't get a hold of her. And she never called me back. And then after like 3 weeks after took my stuff and all that, that's whenever I finally, she called me after that happened. And I said, I already signed the paper. I couldn't get a hold of nobody.
And did y'all talk about, again, you have a right to set aside the MDA and parenting plan?
She never said nothing about that. She was pretty upset. She just said that I was stupid for what I did, pretty much. And I said, well, I didn't know what else to do.
And you talk about she had all your stuff. You're talking about the baseball cards, right?
No, she took $1,200 cash, baseball cards, some silver, some gold that I had, ammo. She took a lot of stuff.
How long were y'all married?
12 years.
And to be fair, a lot of the baseball cards you had gotten during the marriage?
No, I've had those since I was probably 25.
Good. She's going to testify there were a lot of the baseball cards that were gotten during the marriage. Is she
Some of them.
inaccurate about that?
Some of them were, but not all of them.
The $1,200 in the bank, was that marital money?
No, it was just cash I had in a safety deposit box that she took.
How long had you had that cash?
My mom gave it to me a couple weeks earlier because I had no money.
But it's money you had gotten during the marriage?
No, we've been separated for 6 months.
Legally married?
We were married still, yeah, but we were in the process of all this.
And you said the $1,200 in the baseball cards, what else was there?
Some silver
Silver?
and some ammo, like ammo, yeah, for gun.
Did you ever get the silver and the ammo?
No,
Was the silver and the ammo, was that gotten during your marriage?
yeah, I'm sure it
Let me
was.
interrupt you. Are you talking about silver or gold?
Silver and gold,
Silver and gold?
yeah.
Yeah.
So both, and that was what when you're referring to the precious metals or whatever, and you make, one time you say gold, the next time you say silver, is that because they were all together?
Yeah, it's like I had like some Trump silver coins
Okay.
that I'd gotten over the years, and then we had some gold that we'd gotten over the
All
years.
of that was in one place, and that's what you're saying was taken?
Yes,
Oh, okay, I just want to make sure. And you testified earlier that that was worth $30,000?
well, yeah, we had $30,000 worth, and we were supposed to split everything up.
And it's baseball cards, right? Just 30,000 in baseball
No,
cards?
that's
He said 15
15
earlier.
in baseball, about 30 in gold and silver.
Okay.
Okay. I just was,
And we just
because
never
that's
did
been
it.
interchangeably used, one time silver, one time gold. I apologize for interrupting, but I was trying to make sure of what I knew. So.
I'm sorry, I didn't say it
No,
right.
that's all right, go ahead.
And the baseball cards you got back?
Yeah, the police officer, the deputy, got the cars back for me.
No charges?
No. Well, like you're saying, the deputy told me that since we're still legally married, that I couldn't really do nothing about it. I guess because even though I was on a separate property in a separate place, he said since we're still married, she was able to come and do that. But then I talked to Detective Phillips, and he said I could still file charges. So I don't know.
So when you signed this agreement on the 13th at the UPS store, I want to make sure I'm clear about this. Your testimony is that you met her at the UPS store and you went in and signed just the signature page alone, and then you left.
Yeah.
Okay. And you had the boys with you when you were at the UPS store, and that was kind of an exchange time. They went with
Yes.
Ms. Dunham, correct? Mm-hmm. Okay. So, I mean, she wasn't withholding the kids when you signed the agreement now, was she?
No, I had them that day.
You had them. Mm-hmm. And you met her at the Compassion Church building prior to going to the UPS store, correct?
No, I met her at a park. We talked at a park, and that's the changes you said that were made.
Was that near a park? I mean, was that near the church?
He wasn't done speaking, or he can finish. He was saying in the changes that you made and he was going on, but Mr. Long.
Let him finish his answer before he asks the next question.
Yes.
Yeah, it was a park, at Buckner Park. We met at Buckner Park, and but she would never let me see the paperwork. And she just said, "Oh, we'll just make a couple changes, and I'll just go through the paralegal at your office." And so she just made a couple changes, and then she said I could have the kids after that. And that's whenever we went to the UPS store.
So when you say make change, you're at the park and make changes, what changes were being made?
I'm not sure. She was just making changes that I was like, I don't think that that's right. And so she made a couple changes to the paperwork, but I never ever got to see the paperwork. Just whatever she made changes with the paralegal. I can't remember what it was. Maybe the
But when you were, I'm sorry.
amount. I don't know.
But when you were at the park and you're discussing the changes, my question is, what changes were made on that day? Or what changes were made at the park between the two of you?
I'm not sure. We were just talking about all the stuff because after the stuff that had already happened and with Miss Roberts and everything, we started talking about the stuff, the Cree, And there are certain things that I was like, well, that's not right. I'm not gonna sign nothing. I mean, something's gotta happen here, change it money-wise. And she said, well, she would just be like, well, this will happen, like the parenting. Because I wanted joint custody. No, you're not getting joint custody. So then it was like, well, I'll work with your work schedule. We'll just say Tuesdays, but then we'll work with your work schedule. Well, now she only work with my work schedule. It's stuck with Tuesday. I mean, now she only let me see my kids if I have my schedule goes week to week.
Is it
I might
fair to,
have a Thursday off, and then she's like, no, you're not seeing them.
but is it fair to say at the time you're talking at the park, you just brought it up, that you talked about making a change that you get to see the boys on Tuesday?
No, to where I could see them more often or work with my schedule because my days off go week to week instead of like a normal work schedule. So I was like, I can't say I'll be off Tuesday, I could be off Friday.
But then you,
And with that,
go ahead.
so I'm just saying, something like that, change like that, like my work schedule, because I know how she can do, and she might not let me see my kids. Once it's already done, she might say, well, which is what she's doing now. Well, you said Tuesday. Well, if you're not off, you're not seeing them. And all I care about is my kids.
But then while you were at the park, you were familiar with the parenting plan enough to discuss the days that you were going to be with the boys.
Yeah, because it's on her phone. She's like, well, here's what it says.
Okay.
But like I said, I never saw the paperwork though.
So your testimony is you went to the park, Buckner Park, y'all did discuss changes. You admitted
Yes.
you did know about the changes to the parenting plan with the boys and the schedule. And she was gonna purportedly go have those changes made to the paperwork. Was there any other, was there any other changes that you discussed?
Not that I remember. I know it's mainly about the kids because that's the most important thing to me. And she actually called your paralegal right whenever we were there. And she made the changes then. If I remember right.
Okay, so y'all negotiated changes and they were made to the paperwork, as far as you knew.
Well, that's what in the paperwork, I told her I wanted joint custody, but then she said, we'll just put Tuesdays and that, she would work with my work schedule, like more, I could see him more often. And, so that's what she made changes to it because it was just one day and now it was actually where I could see him more often.
And
Now she won't.
you made other changes, but you just don't even know what they were. You can't remember.
I don't remember. I think it was just mainly that because I had a problem with not being able to see my kids.
And of course, that entire time you're talking with her at Buckner Park, I mean, you knew you had a lawyer that you had retained that you could take this paperwork to, correct?
I did, but I couldn't get a hold of her.
Well, and you did get a hold of her, it was just sometime after.
She got a hold of me.
May.
Yes.
ask you if you recognize that as well as text messaging between you and Ms. Dunham?
Yes.
And I didn't put them together, but I should have. Those actually kind of go together, do they not?
Yeah, they do.
All right. So starting with did you want to come to the Compassion Building? Is that you texting or is that Ms. Dunham texting? Let the court know that.
That's probably her.
Okay. And what's your response to that? Can you read it?
Yeah, I'm trying to think. I can't tell if that was me or her. It says, okay, I have to get a couple of things ready and take a shower. That might have been her.
Okay.
I'm not sure.
And then what's the next text?
Okay, let me know when you're on your way. Okay.
Everybody agrees with that. And then the next text after that, that's at 10:35 a.m., according to this, says, I'm on my way.
Yeah.
And it says, let me know when you get here. That's one of you saying that, correct? And then basically it's okay, 10 minutes, and then it says, I'm here. Is that right?
Right.
Okay. And then that kind of leads everybody to believe you're at the Compassion Church building, correct?
Yeah.
Does that jar your memory to know you were there?
I'm thinking that we talked at the Buckner Park maybe a couple days prior, and then this was the day we went and met the UPS.
Okay. And this is the day we're talking about, the day that you were at the UPS store and doing all that. You actually met before that at the Compassion Church building.
I think that I met her to take the boys there.
Okay. But I mean, I want to make sure that's a change in your testimony a little bit. You're remembering things based on the text message. But
Yeah.
now you're at the Compassion Church building, correct?
Yeah.
All right. And then, after that, and on November 13th at 1:41, the text is, I'm heading to the UPS store, correct?
Yes.
And according to you, you don't know who that is. It's one of you, but you don't know who it is.
I think that's me.
Okay. I think you're right. Up at the top, it says Michael O. Phone, correct?
Yeah. Yeah.
All right, and that's you, correct?
Mm-hmm.
Is that a
Yeah.
yes? Is that a yes?
Yes.
Okay. And are you aware that when it says that up at the top, all of your text, whoever is up at the top like that's on the right-hand side?
I didn't know.
Okay. Nonetheless, you do believe that was you saying, I'm heading to the UPS store?
Yeah, we met at the UPS store, yeah.
Okay. And it says, okay, you're almost here. Goes on to say, yeah, basically I'm inside. Somebody else says, okay. Y'all going inside the UPS store to sign everything at that point, correct?
Yeah.
Fair enough. And I want you to look at the times when you're talking about being at the Compassion Church. You're at 10:35 a.m., correct?
Yes.
Is that fair? And then at the UPS store, based on everything that's going on here, you're at 1:41 p.m., correct?
Yeah.
So is it fair to say from the time you were at Compassion Church talking about all these changes, you knew these changes were going to be made? I mean, it looks like you had from 10:35 to 1:41 p.m. to think about those changes, at least in your head.
We never talked about the changes there. They that's what they do, their homeschooling. The boys,
I'm sorry, you've got me.
the kids, they do their homeschooling there. We didn't meet at Compassion to talk about any of the changes. That was prior to that.
Okay, so that was a couple of days before that. Your testimony, then you're at Buckner Park talking about changes.
Yes.
So you actually had a couple of days to think about the changes, not just a couple of hours. Is that fair enough?
Yeah, I mean, I already said that because I couldn't get a hold of my lawyer. I didn't know what else to do, so I already said that you had to sign them. Didn't know what to do.
if I've kept up with this correctly or not. I think we're at Exhibit 7, or we're at 8? 7. I would ask this to be collected, Exhibit 7, these text messages.
What?
Did you, when you were terminating Ms. Roberts, did you ask for a refund?
I did.
Okay. Kind of, is it fair to say you weren't wanting to waste the money on an attorney if you could make an agreement?
No, what happened was, I just wanted to get half my money back because after all that had happened, she'd already wrote out all the paperwork to have everything done the right way, but then whenever nothing ever happened, and she called me after everything was signed, I just asked her if she'd at least refund half of it. She wouldn't do it.
Well, is it fair to say that you were getting a half, or at least asking for half a refund to get your money back rather than go through the process of the divorce and all the additional monies, not only that, but the additional monies? Is it fair to say in your mind, you're terminating Ms. Roberts to save money to make this agreement?
It didn't have nothing to do with that.
But you did ask for half your money back.
Yeah, because she filed, I figured since it was filed as contested, and from all I've ever heard that was like $5,000, but non-contested would be half of that. So I just figured since I hadn't been able to talk to her, get a hold of her after all that stuff happened, whenever she finally called me and I'd already signed it, I just was asking half because it was not contested. Because it's not contested instead of contested.
When did you, if you can recall, when did you first tell Ms. Roberts that you had signed this paperwork?
When she called me.
So at the time you're calling and leaving messages, you didn't say anything about that?
No, during that time, I didn't know what happened with her mom. I just thought she just wasn't able to get to me. So I told her about her breaking in and taking my stuff, and I said, I don't know what to do. I have no way to pay nothing. And I said, I need someone to give me a call back. And I called her about that, and I asked her what was going on with the court case, because I hadn't heard nothing about that. So then I stopped by her office a couple of times, and she wasn't there. And after that, I didn't, and then after 3 weeks, I believe it was almost 3 weeks, she finally had called me back and said she had an illness in the family and she was sorry. And I said, well, I've already signed the paper. I didn't know what else to do. I'd given up.
And then at that point, you were saying, I'd like to have half my money back. Was that conversation?
Yeah, when she called me back, she said, I can't believe you signed the paper. She said, I said, well, I didn't know what else to do. I've left you message after message. I said, and then after we talked for a little bit, I just said that I didn't need her services no more. And she said, well, let me take a look at the paperwork first. And I said, okay, we'll take a look at the paperwork. And then after she did that, that's whenever I asked her if she could refund me half the money back. She said, no, she said, I'm not going to be able to do that.
Let me just be clear and make sure I get this under oath. Is there ever a point in time that you ever saw this paperwork?
After the decree was finished, after the final decree was done.
Okay. So at the point in time the final decree was done, that's when you saw the paperwork?
Yeah, once the final decree was done, I saw the paperwork.
Did you get it in the mail?
Yes, sir.
Okay. Are you aware that you had time to still object to that, 10 days or so to object to that?
No, but once I looked at all the paperwork, I didn't know how to go about getting a lawyer. I had no money. I didn't know what I could do. I thought I had to come up with the money for another lawyer. And whenever Miss Roberts wouldn't refund me the money, and I'd had all my stuff taken, I didn't have no way to do anything. So once my mom was able to, they sold their house. When they sold their house, a month later, that's whenever they paid for the lawyer for me.
You may.
Text messages. Do you recognize those text messages?
Yes,
And that's text messaging between you and Ms. Dunham, correct?
yes.
I believe that's you at the top. Can you read what you, and if it's not, stop me, but I think it is. And if it's, well, can you read what you put there at the very front?
Yes, where it says, I talked to Heidi.
Yes.
I talked to Heidi. She is doing some online jobs because Andy's work has been slow to help. If you could do something like that to help, I could pay the house and the utilities, then you would only need your $1,400. Then I could help with other stuff as needed.
And that was on November 11th, 11:16 PM, correct?
Yes,
All right. And then her response was to that, looks like it's November 12th at 8:59. Is that right?
yeah.
Can you read her response?
So you will agree to pay for everything else you said you would pay for, just not give me the $1,400 I used to take care of me and the boys.
And then what was your response to that right after it?
Yes, that is $3,000 a month. If you just got a little job like Heidi to help, she has some information. You could probably make more than $1,400 a month. Then I know I could keep up with everything. So if my mom moves, I could at least afford something, and the boys could have both of us.
And again, your reply was on November 12th, correct?
Yes,
And her response was, I'll pray about it. Is that right?
Yeah.
Okay. So I mean, is this fair to say that on November 11th and 12th, you guys are discussing the details of your agreement?
yeah,
And at some point, you're talking about the $1,400 a month that you guys were, talking about as far as her needing for the boys and the spousal support, correct?
yeah.
Okay. So you knew that was there,
Yeah, like I said, the most important thing is my kids.
but knowing that was there, you're still, sounds like today, your testimony with the judge, you're still kind of objecting to having to pay for all that because you didn't realize it was there.
That's because I got everything taken from me. I had no lawyer to talk to. I didn't. That's why I agreed to it, because I want to see my kids.
Now, you understand my point. This is on the 11th and the 12th. You guys, my point is, you knew about it.
Like I said, I hadn't talked to my lawyer. I talked to her 3 days later when she called me after I hadn't been able to get a hold of her for 3 weeks.
And again, back to your point, you brought the kids with you to the UPS store when you signed it, correct?
Yeah,
So you weren't missing your kids on that day, were you?
because I got to see them that day, yeah.
Judge, if I can, I would like to move that for collective, Exhibit 8, just one page.
All right.
And while we're on the subject of the spousal support, this money that you're talking about here in your text, Are you aware that, you know, the spousal support in the MDA is for the mortgage, the utilities, and the taxes?
Yes,
Yes, yes. And, you know, it's not just like, we agree, fund money that Ms. Dunham has to go do nails and hair and get a new car, do whatever. She's to take that spousal support and spend it on the mortgage, the utilities, and the taxes, correct?
yeah, but it's $3,000 a month.
And the mortgage is
I
how
don't even
much?
make that,
And how much is your mortgage?
2,300,
And how long had you been paying that while you were married?
6 months.
Because she didn't work during the marriage, did she?
No, she had a part-time job, I think.
When was the part-time job?
Well, she's been doing like a thing with the homeschool group. She works with the homeschool group.
Fair to say it's a nominal job to begin with. She wasn't making any.
No, about 8 or 10,000 a year.
Do you have any reason to believe that Ms. Dunham was not using the spousal support money to pay for the mortgage, the utilities, and the taxes for her and your boys to live in?
No, I know she was.
In fact, when you stopped paying it, or at least reduced it, let's put it that way, you were paying the amount, I think it came out to be $1,400-1,500 a month, right?
Yes, $1,500 a month
And then you reduced it to $750 and made that payment for a while, 2 months,
for
3.
the last 3 months, yeah.
Yeah. Then you went down to $500 a month.
Well, that's because they took my Christmas bonus and sent her almost $1,500 last month.
And because of the reductions in the spousal support payments to her from you, you're aware she got behind on the mortgage.
Yes,
And I think you've already testified to that. I just want to make clear, you're aware that she sold or had to sell some of the property she had to get the mortgage even caught back up.
yeah,
Are you aware in the MDA that you signed, if you got behind on any of this stuff, you still had an out to give her half of your, I think it's half of your 401k at the time of the divorce?
well, I have no other choice. I can't pay for all that.
Are you aware
I
that you
don't
had
have-
that option? That's my question.
I wasn't aware of that.
I'm sorry, Judge, may I have just a second? Approach.
You may.
This accurate, this is your MDA filed November. Chance to look through that MDA, make sure your signatures are on the back or whatnot. Paragraph that I'm talking about right here. My first question is, do you recognize that as your MDA that you signed, that you and Ms. Dunham executed on the 13th of November, 2023?
Yes.
Okay. That paragraph that I was pointing to, can you read that paragraph into evidence, please, sir?
It is further agreed that should the husband not pay the spousal support, then the husband agrees that the wife shall be entitled to half of any of all 401ks as of the date of the judge signed stamp filed of the final decree of divorce, and further, that once the wife receives her one half said 401ks, then the wife shall deduct the amount from the husband's monthly spousal support payments, and the husband shall pay any and all remaining spousal support payments till the youngest child reaches the age of 18 and graduates high school, whichever is the later.
Fair to say, based on this paragraph, even if you got behind on what you're behind on now, you've got an out to give her half of your 401ks, and she still has to use it for everything she's supposed to use it for, but at least you've got an out in this MDA.
Okay,
Fair enough?
yeah,
Okay. So the reality of this is, you know, you may be behind or having needs on spousal support because of, we'll talk about it in a minute, your high blood pressure or whatnot. But at the same time, you got an out here in your MDA that you've not even looked at or taken, correct?
guess so.
I'm gonna object. That's a misrepresentation of what it says. He's misrepresenting exactly what the MDA says. MDA doesn't say that. It says she has an out. It doesn't say he does. It says she may opt to go after the 401k. It doesn't say that he can.
Well, I would respectfully disagree with that. Then the husband agrees that the wife should be entitled to one half of any and all the he agrees that she's entitled to one half, and all he's got to do is do it. And there's no way that we can void that in the MDA.
But it doesn't say that.
I just read it. Then the husband agrees that the wife shall be, and he did too, the husband agreed that the wife shall be entitled to one half of any and all 401ks.
But it doesn't say what vehicle to which that is to be completed, is what I'm getting at. It doesn't say he can tap into it.
Well, the question I have is, of course, it says if it further agreed that should the husband not pay his spousal support, does that mean he never pays it, or he misses one payment, or what? And then the husband agrees the wife shall be entitled to one half of any and all of his 401ks as to the date of the judge signed, stamp filed copy of the final decree of divorce. And further, that once the wife receives her one half of the 401ks, then the wife shall deduct that amount from the husband's monthly spousal support payments, and the husband shall pay any and all remaining spousal support payments until the youngest child reaches the age of 18 and or graduates from high school, whichever is later. You know, I can understand how a layperson might be a little bit confused by that, but basically it says if he doesn't make a spousal support payment, then she triggers that and she gets one half of his. If he misses one payment according to that, then she gets one half of his 401k, and if she gets one half of his 401k, she deducts the amount of that monthly support payment, and then he'll continue paying any remaining spousal support payments, which means he misses one monthly payment, that triggers that. She then gets half of his 401k. He has to then continue paying the remaining spousal support payments after the deduction of that one that he missed.
But my position is, Mr. Hawley is representing to this court that it triggered him going into his 401k. The way I'm reading it, it triggers her ability to go.
I agree with your interpretation. It's not something he gets to choose to do. It is a right that she's given under this.
Right.
More concerning is that it doesn't specify that she deducts all future remaining monthly support payments, and then he'll pay any and all remaining support payments. It just says she'll deduct the support payment that he missed. So one interpretation this could be given is he misses one support payment, she gets to one half of his 401k, she deducts that one payment, he has to pay the rest. I know that's not what was intended. I'm just saying that the language is confusing at best.
I just didn't want it misrepresented.
I agree with your interpretation, Ms. Duke, that it is not an option he's given. It's a right she is given under this agreement.
Thank you, Judge.
So, well, I'll save that for closing. If she was to get one half of your 401ks, I mean, you're aware that that requires signatures from everybody and that you would have to do what's called a quadro.
I guess so, I don't know.
And she never did this. I mean, you or her, no matter whoever was supposed to have done it, nobody's ever done this yet, correct?
No,
Or do you have any issue with half of your 401k going toward the spousal support payments at this point?
I mean, I've got loans out on all of them. She told me to take a loan out before to pay for something. So I've got 3 loans out on my 401, just trying to keep up with all this. So, I mean, she's got everything else. She can have it too.
Well, you're aware that, you can't really get a loan on more than half of your 401k. Are you aware of that?
Yeah,
So the half of the 401k that we're talking about here is still in your 401k, right?
yeah, I got a loan out for half of it.
Yeah. So do you have any issue with her getting the other half, and that would equal out the spousal support payments?
I don't guess so.
I mean, is that addressing the motion, or is that addressing your motion for contempt for not having paid it?
Yeah,
It
and I
seems
was
to me-
I think it's both.
I will say, I was gonna object earlier, but he kept tiptoeing back to the motion to set aside, or the motion, the Rule 60 motion. So I didn't make that. I mean, really, he's allowed to plead the fifth on that motion for contempt. It's just, it's weird, it's so out of order, and not out of order, but it would be out of order him asking those questions, so.
I'm hearing the motion under Rule 60.02 to set aside the final decree and parenting plan. I am not going to consider the options that he may have to try to cure any contempt that he has, because until we determine the validity of the decree and a marital dissolution agreement, it seems to me that we're far flung it. We're at the noon hour. This horse may not be deceased quite yet, but we'll continue beating it until it is after lunch. So
Yes.
we'll stand in recess until 1:15.
All rise.
Good.
He needs to come back to the stand, please, Mr. Dunham. Mr. Holly, I believe you are still cross-examining.
Yes, sir. Mr. Dunham, when did you first let Ms. Roberts know that Ms. Dunham had a lawyer? Me, representing her.
I would say the first day I talked to her, first day I went in to talk to her.
Do you remember about when that was?
I'd say middle of October. I'd say October 10th, 12th.
Okay. So you informed her then that I was representing Ms. Dunham?
Yeah,
Okay. So you had retained her in the middle of October?
it was later on, like towards the 20th,
Okay,
19th, 20th.
all right. Do you have any reason at all why she didn't serve me with the divorce papers?
I don't know. Like I said, it was like whenever I retained her, she wrote everything up. I come in and then I looked them over, and then she was going to put them to the court, and then that's whenever she went rogue for 3 weeks, and I didn't talk to her till after November.
Well, from October to November 13th?
3 weeks.
Yeah, okay. And
She had all the paperwork filled out, and I thought it was filed, and that's whenever I started. A week after that, I checked in. She said, "Well, I'm about to send it out." That was towards the end of October, and then that's why I didn't hear from her.
again, just to be clear, when did you first tell Ms. Roberts that you wanted to terminate her services?
Whenever she called after I hadn't heard from her, probably about middle of November. I guess that. Whenever she called after she finally come back, it
Was it before or after you signed the documents?
was after.
Okay. So a couple of days after you signed these documents, then you told her that you wanted to terminate her services?
Yeah, because I already signed them and I hadn't been able to talk to her, get a hold of her, I didn't know what to do. So met her and signed it, and then she called a few days later, and I said, I've been trying to get a hold of you, trying to get a hold of you. I said, I've left message after message. I said, I signed the paper. She not letting me see my kids, and I said, I don't know what to do. I didn't know where to go. She took my stuff, broke in and took my stuff. And she said, well, you should have never signed them papers. I told you not to sign them papers. Or sign any kind of papers. And I said, well, I did.
Okay. At the time you did sign the uncontested divorce paperwork, though, we're fair to say that there was nothing on file as far as a contested divorce.
When was that?
At the time you signed the uncontested paperwork, which I believe we've established was November the 13th,
Yes.
there was no contested paperwork that was filed.
No, not filed, I don't guess, because she never did file it. She had it wrote up, I guess it never got filed.
Okay.
You may.
Termination of legal services letter that you actually wrote to Ms. Roberts?
I never wrote it, but yeah, it's something she sent me.
Okay.
Kara sent it to me and said this would be a good way to terminate her.
And you signed it and
And
sent
then I
it?
signed, yeah, and then I signed it, yeah.
Okay. So you relied on Ms. Dunham to help you with that as well?
Yeah, I got a lot of text messages. I asked her, I didn't know what to do. I was like, I haven't been able to get a hold of her. I don't know what to do.
And you said per our phone conversation, which you're talking about the phone conversation you had originally with her that we talked about, which was around the time that, shortly after that you signed the paperwork.
Yeah.
Okay. And if you can, read that middle paragraph, please, for the record.
As we discussed, I am terminating this relationship because I have come to an agreement with my wife for an uncontested divorce agreement and parenting plan. I called your office to cancel the contested divorce paperwork I had signed with you. I had to leave a message. At the time I signed the uncontested paperwork with my wife, the clerk's office did not have anything filed. When I talked to you the next day, I informed you of an agreement and my intention to not use your services and to have you not file the divorce paperwork you had. I later found out your office had filed paperwork.
All right. Is everything in that paragraph true and accurate?
Pretty much so, I guess. Let me see. Yeah, but it's not completely, because I actually left three or four messages, and I went to the office a couple times.
All right. Judge, if I may, Exhibit 9.
May. Who wrote that letter?
You did?
Stu did? Or your wife wrote the letter to
Yeah.
terminate your lawyer services? I was wondering because the way you were reading it. So.
Yeah, she
Okay.
did.
Yeah, that's,
I need to go back on the record, and I think now is a good time to do it, just as it just happened. But Mr. Holly.
Turn your microphone on, please.
Mr. Holly made mention of the date that the complaint by Ms. Roberts was filed and in correlation with when he signed, and I think those documents speak for themselves, and they're actually on the same date. It's November
the 13th.
Yes, I just wanted the court to be aware because he was asking that question, and the dates speak for themselves.
yes, sir. And it all is on the 13th, but the service was on the 15th. And then apparently from your testimony around the 13th, when you were talking about letting her know originally that you were wanting to terminate her services, as you put in the letter.
No, that was after I talked to her a few days later.
Right, the 13th and a few days later after that.
No, not the 13th. It was like the 15th or 17th.
Okay,
Whenever she called me.
okay, whenever she
I
called.
never was going to terminate her services at all.
But how does that say in the letter then? It says as we discussed. in per our discussion?
Because it was like a written up letter. I didn't write it. I don't know.
Okay. But you didn't disagree with signing it and sending it, did you?
No, after I talked to Miss Roberts,
Yeah.
and I did send it to terminate the
It's
service
what-
because I already signed the paperwork from you.
It's what you wanted to do.
Yeah, after all the stuff that happened to me, yeah.
So you talked about
I
your
gave, I
health.
gave up.
All right. So you talked about your health. Said you had high blood pressure. Right? Are
Yes.
you on some kind of medication?
Yes, sir.
All right. So what are you taking for your blood pressure? Okay. And with those drugs, is your blood pressure fairly regulated?
It has been now lately.
And talked about your elbow.
Yeah, it was like carpal tunnel tendonitis, and I had like a tear in the ligament.
Good. And when did you say that you hurt that letter? I mean, hurt your elbow?
2019.
Okay. And you went to work after that?
Yeah, I had to go through physical therapy for 4 months, and then I went back to work after that.
Okay. And granted, there were some years that you were in there at, $80,000, $90,000 of salary working, after that. Is that fair?
Oh, yeah, yeah. I averaged about 80,000.
All right. So with the amounts of money that you were supposed to pay in the MDA, when's the first time that you were delinquent? Or you missed a payment or shorted a payment? Or you couldn't make the payment?
I think that I was probably probably 3 months ago, I'd say.
Okay.
2 to 3 months ago.
But outside of that, you'd been
Well,
able,
well, what happened was I had a check that was like $3,000, and after they take out tier 1, tier 2, federal taxes, everything else that they take out, my whole check went to her like $1,267 because I was paying $1,500. And after that, I thought, I can't go without no money. I don't have gas to go to work. So after that, I changed it to $750.
yeah, right. And you talked about that being just a couple of, 3 months ago is when you started?
Probably 2 or 3 months ago, yeah.
Okay. So from the time or basically the time of separation to 2 or 3 months ago, you were able to maintain that?
Yeah, it's because I was staying in my parents' property rent-free because they had their own house with a cabin. They let me stay in that cabin without any kind of expenses. So all I needed was gas to work and food. That's about all I could afford. Plus, in that time, I had 3 loans taken out to try to keep up paying everything. And I also had to
Go ahead.
sell a lot of my stuff.
Since that time of separation, pardon me, since the time of your divorce, I thought you said somewhere in August is what I had written down, is when August of 2024, you would have started seeing someone and you were engaged.
Oh, this year?
Yeah.
Yes.
Okay. And well, did you get engaged in August? Let me ask you that.
Yes, sir.
Okay. So did you take a trip to Florida with your fiance and the boys?
Yeah, my mom was there. So I took,
When did you do that?
If he can finish, Judge, you interrupted him
Never
again.
I'm sorry, finish your.
Please let him
finish your-
finish before we begin asking the next question.
actually, it was Alabama. We went to Alabama. My mom and my dad lived there. And my son's birthday was September 23rd. It was his birthday, and he hadn't seen his grandma in a year, or 6 months to a year. And I took him down there for his birthday party.
All right, and it was on the beach at Alabama, right?
Well, they don't live on the beach, but we went to the beach. It's about
Okay.
10 minutes from the beach.
All right. And how long did you stay there?
4 days.
All right. Did y'all rent a hotel room there?
No, I stayed with my mom.
Okay, so you just drove back and forth to the beach.
Yeah.
Okay. Your fiance, did you buy her a ring?
No, my mom gave it to her.
So your mother gave her a ring?
Yes.
You spend any money on your fiance at all?
No, she usually has to pay for me.
Okay.
She's a nurse.
talk about homeschooling. You talked about throughout the course, Mr. Duke had asked you about how much that was and whatnot, and that you wanted the kids to go to public school now. That was your wish.
I always have.
Always have.
Yeah.
So when I look through it a minute and pull out a text that says something to the effect that you didn't want the kids to go to public school because they were going to be corrupted, that's not going to be accurate.
Well, I had thoughts about that, about being corrupted, but I went to public school, and I guess over time, maybe years ago, but over time, I've seen that, I mean, they can barely read and they can barely write. I mean, for a 12-year-old to not be able to write a paragraph, there's something wrong. I think that they need to get a tutor and someone to help them with reading and writing, math.
But your testimony is then you've always wanted them to go to public school.
Yeah, I mean, I worry about corruption. I know there's some bad things, but I think that public school would be better for them.
You may.
So is this a text message that you recognize between you and your mother?
Yeah, I think so, I guess.
Okay.
Mom.
So that two paragraphs on the right that are dark. Can you read the first one and the second one, please, sir?
The dark ones?
Yeah, that's your writing. Is it, that's what you're texting your mother?
Okay.
Is that, well, you tell me, I'm asking.
I don't know, it don't have my name, I guess it is.
You remember
But
that
I can
text?
read it.
Okay, you just testified it was. So go ahead and read the block up there.
We're sharing equally, but she has no job really, so with homeschool, I have to pay for it all, they said.
And the next paragraph, please, sir.
I would rather struggle for her work. The boys go to regular school and get corrupted and have babysitters.
You remember when you and your mother were texting this?
I have no idea.
Okay. Exhibit, I believe we're at 10, if I'm correct.
Judge, I'm going to object if we don't know when this was written.
I don't even know.
Well,
We
he's
haven't
already
established
authenticated it
when
as a document that he recognized between he and his mother.
But it's not pertinent to anything unless, it could have been written when
said
these
mom.
kids were in kindergarten.
You be quiet while we're talking.
It could have been written when the kids were in kindergarten. We don't know.
He
Or when the
testified,
kids were supposed to start school.
he just testified he never, well, he always wanted the kids to go to public school, and that says just something totally different. So it goes against his credibility, and he's already authenticated that's his text with his mother.
It doesn't go against his credibility because we don't know when it was written. We don't know that he didn't go into any more context about whether or not he still agrees.
Well, I haven't seen the document. Let me take a look at it.
He just said that he always wanted the kids to go. I just asked him that twice. He always wanted the kids to go to
No,
public
that's
school.
not what he said.
That's exactly.
It doesn't have a date. It does show that it's between him and his mom, and my understanding was he acknowledged that that was a message between him and his mom. I'm going to overrule the objection, allow it to come in solely for the purposes of credibility. Overrule.
Is this number 10, exhibit number 10?
10.
Yep.
You may.
We'll show you this document and ask you if you recognize this document. 2022 tentative national agreement kind of lays out your pay raise for 2022 and beyond. Do you recognize that?
Yeah, I believe so, yeah.
You gave it to us in discovery, I believe. Is that accurate?
Yes.
So, all right. As far as this goes, it lays out percentages of pay raises. 2022 looks like you're getting a 7%, 23 is 4, the other's 4.5%, correct?
Yeah, they've already, all of them's gone through.
Yeah. And it's got your annual earnings basis on this and what your retroactive pay would be, correct?
Yeah, but it don't, that's just like an average. It's not what everybody makes. Like, it's not to say everyone makes that much money. It goes by seniority. Like right now, I'm on an extra board. They've got a freight pool, they got a freight 1, a freight 2, and then they got an extra board. The guys on the F1, the F2 won't make that much money. Someone on the extra board will make considerably less.
Okay. I'm just saying, this is something you gave to me, right?
Yeah, that's what, on average, that's what it would be, yeah.
Okay. And, I mean, it's fair to say you do get pay raises, you've got good benefits at your
Oh,
work.
yeah, we get good
You
benefits
have
and, yeah.
a good job.
Oh, yeah, yeah.
Okay. I'd ask this to be Exhibit 11. He's all right.
You may.
Recognize this? Text message between yourself and Ms. Dunham about your engineer pay? Okay. That's good to recognize it. Do you recognize this? And again, it's recognized as a text
Yes.
message between you and Ms. Dunham, correct?
Yeah, I recognize it.
All right. And can you read that first paragraph?
It's okay. I'm gonna have a lot of big checks coming up. Engineer pay is more than I thought it's like $150 more per trip. 800 more every 2 weeks.
And when did you have this text message? Thereabouts?
I think that was years ago, whenever I first got to be an engineer.
Okay.
I don't think it was recently, maybe like 7 years ago.
Okay.
Judge, I'm gonna ask that that be stricken then. Not relevant.
Sustained.
May I approach?
You may.
And you're still an engineer though, correct?
Yeah, it's weird. Like I said, like I'm at the bottom of the list on the extra board, and every once in a while they'll send me back to conductor, like I did right before Christmas. I was cut back conductor for 3 weeks, and now I'm back on the engineer extra board. And the pay's a lot less on the extra board. Like when I'm a conductor, I can make more money. So I had a good check about a month and a half, 2 months ago, but then they moved me back to engineering. It's pretty much just a guarantee because you only work a couple days a week.
All right, so I'll strike that. As far as the FMLA goes, you've taken FMLA for personal things as well, such as the kids' baseball tournaments and things like that. Father came in, I've got a text about that. It's fair to say you're taking FMLA for some other reasons as well, other than your health reasons. Is that
Judge,
accurate?
I'm going to ask that the court strike part of that statement, because Mr. Hawley, and he's done it throughout the entire hearing, testifies for a minute, says, "Oh, well, I have a text about that." Just ask the question, and if he has a text, present him with the text.
I'll rephrase.
I think
So you're objecting to the form of the question as argumentative?
no, I'm objecting to the form of the question as testimony, because he's testifying and saying these things. I think it's his way of influencing the court in the court hearing those things, that, hey, there's a text that exists that says this.
Let me assure you
Well,
that this
I don't-
court has done this long enough that I do not take a question by a lawyer as evidence. So
Yeah,
sustain the objection.
Thank you, Judge.
I'll rephrase. So is it fair to say you are taking FMLA for visits with your family and other things?
Not necessarily. I mean, like, if I come back, people don't understand it. As an engineer, them train rides aren't very, I mean, they're bumpy. And I've got FMLA for my arm, I've got it for my back, I've got it for my blood pressure. And a lot of times, if a family member's coming in town, or if my kids have a game, when I come back from a trip, I'll take off. And then I'll go to the game too. It's not like I'm just taking off just to go to the games.
Have you ever gone to a game while you're on FMLA?
Oh, yeah. Yeah, I have.
Have you gone to visit with family, or family come to visit you while you were taking FMLA?
Yeah, family's been visited whenever I had it, when I was off FMLA.
Judge, I don't know what relevance this has to the Rule 60 motion about family coming and visiting while he's on.
It doesn't.
I would ask that all of that testimony be stricken, and that Mr. Hawley be instructed not to continue down this road.
May I respond?
You may.
He's already testified that he's taking, or he's testified on direct examination that he's got issues and he's taking FMLA, and that's the reason why his check is apparently less than what it is. This is just to ask the question, it's not just FMLA for your physical injuries. You're taking it for your personal reasons.
And how does that relate to a Rule 60 motion that Ms. Duke has filed, that we are supposed to be hearing?
I would answer that because she put it in direct, the door was open, and I'm responding to that because my understanding, she's offering the evidence to say, Mr. Dunham can't afford this anymore. Mr. Dunham can't keep up with the payments, and that's why this is, not fair to Mr. Dunham, and all of these things. And she brought up the FMLA in direct about, this is why your pay is less, because you've got an issue with your elbow, you've got high blood pressure, and all of those things. So I'm offering it to show, no, it's not just that. He's actually used FMLA to be with his kids, to take family time, to do other things, and that's the reason why his pay is less.
All right, I'm going to allow the testimony that would just simply observe that a marital dissolution agreement is a contract between the two parties, and therefore the laws of contract apply. Unconscionability of a contract or an agreement is something that can nullify an agreement if the court finds that unconscionability is applicable or is present. That simply means that if an agreement is so far one-sided in favor of one and against the other as to be unconscionable, then that is a basis under contract law to set aside an agreement. The issue that Ms. Duke has raised is that it is unconscionable, at least arguably, because he is not able to pay the amounts that he is obligated to pay under this marital dissolution agreement and the parenting plan. Therefore, Mr. Holly would be entitled to go into issues to rebut that argument by saying that it's the FMLA, the Family Medical Leave Act, that he is implying, or he's using to allegedly reduce his income is what he argues is that he's doing other things to, with family and taking trips and so forth instead of working. So I'm going to allow it. We'll go till 4 o'clock today, and then we're not coming back tomorrow morning because of the simple fact that we're expecting a large snowstorm to hit us. It's closed when? So we won't be here tomorrow because the courthouse is closed anyway. So anyway, I'm allowing that, but I'm making you both aware of the way that I see this. It is not just a Rule 60 motion arguing that it was fraud or undue inducement. It is also arguing that it's unconscionable in the fact that it's so one-sided. So go for it.
Well,
You don't have to say anything else, just ask your questions.
I am, Judge. And I believe I'm about done. I'm just, if I could have a second to go through my notes, make sure I've covered everything. May I have a vote by client?
You may.
With him that you feel like you can't testify to. I gotta talk more text and stuff that you're gonna talk about. Yeah, anything that you can't testify to.
Ms. Duke, you have redirect?
I do, just a few questions. When Mr. Hawley was speaking to you about your 401k and all of that and how you could pay out of your 401k, your 401k is how much?
I've got two. One's about 13,000, the other one's 15,000.
Okay, so a total of 28,000. That, would that even cover 6 months of what you're having to pay her?
No.
Okay. And when you were making the payments and trying to make the payments work, were you having to borrow from your mom and dad?
Yes.
Okay, and were you having to take out loans?
Yes.
Okay, and are you at an end of like, can you borrow anything else at this point?
No, I've got two loans on one 401k, and the other one you can only have one loan. I've got one loan out on it. And my mom's actually paid my rent where I'm staying for the last 5 months. She couldn't pay it anymore, so now I'm having to pay it, trying to pay it. That's one of the reasons why I quit paying the full $1,500, because I have to have a place to live.
Okay, and this termination of legal services that you wrote to Miss Roberts, you didn't write that, she did, is that correct?
Yes, she did.
Okay, and at no point in time did you talk to her the next day? You didn't talk to Jennifer Roberts the day after you signed this agreement, did you?
No.
Okay. Did you read this before you signed it?
Yeah, she did some kind of layout thing and sent it to me. Said this would be a good way to terminate their services.
Okay, and
And
did you,
she told me just sign it.
okay, and did you follow her instructions about just signing it?
Yes.
Okay.
You
Now,
were saying she told you to just sign the letter of termination without,
Yeah,
or the
my ex-wife did.
I know, but I'm saying she said to just sign it.
Yeah, it was like a layout. She sent it over the phone and said, here's a layout, a good way to terminate her services and just sign it. So I did.
and this was on this was in December when you signed this, is that correct?
Yes.
Okay. And you don't harbor any ill feelings with Miss Roberts, do you?
No.
Okay, she was having family issues and you don't fault her for that at the time, do you?
No.
Okay. As a matter of fact, Miss Roberts contacted Mr. Hawley before she filed her petition, didn't she?
Yes.
Okay. Asking if he would accept service.
Would appear to be hearsay to me.
Judge, may I have exhibit number 8? Now, Mr. Hawley kind of skimmed over this. May I approach Judge?
You may.
You said, yes, that is it, $3,000 a month. Was that the amount in total you thought you could pay her, including your child support and everything else?
Yes.
It wasn't the $6,796 or whatever it was that's on the income sheet
No.
or on the expense sheet, I'm sorry. And Judge, the one that you let come in, in between number 10. Hypothetically, let's say that this was sent to your mother during your negotiation I'm just giving him a time period.
Do what?
I'm giving him a time period. I'm not asking you to testify.
Overruled.
What was your understanding about custody? Tell her about that. What did you tell your mother about that?
I told her that I thought we'd have joint custody.
And on that, how did you word it?
We are sharing equally, but she has no job really. So with homeschool, I have to pay for it all, they said.
And so your understanding of what the agreement was going to say, when you were signing.
I'm going to object again to the reading.
You're entitled to question him about what it represents, but that's not a basis for an argument for an objection, but your leading is, your objection on leading is sustained. Don't lead the witness.
We are sharing equally, but she has no job, really. So with homeschool, I have to pay for it, all they said.
And let's hypothetically say that even if that was only as pertaining to expenses, were you still saying you thought you were sharing everything equally?
Overruled.
What was the question again?
Okay. Let's say hypothetically that it is only applicable to the expenses. Did you think you, in that agreement, you were still sharing everything equally?
No,
Okay. Did you think that you were going to get help from her, though? The 14, tell me what you thought the agreement would read.
I thought the agreement would be that, I'd get joint custody of my kids and be able to see them half and half. And that she was gonna get a job and we were gonna pay for things equally, half and half, and we were gonna split everything half and half. And that's what Miss Roberts, when she wrote out the paperwork the first time, that's what it was.
Okay.
And she never got filed.
And did Miss Dunham know that Miss Roberts had been retained?
I told her after I retained her, yes.
Okay. Did Miss Dunham ever represent to you that she had let Mr. Hawley know that?
Yes.
The FMLA issues came up just a second ago. In order to take FMLA, do you have to have anything from your doctor for it to be approved by the court?
Yes, every year.
Okay. And so if your doctor doesn't approve you, can you take FMLA?
No,
Okay. And when Mr. Hawley was asking you about taking off for ball games and things like that, would you have already been off on FMLA at the time?
yes.
Is there anything in the FMLA paperwork that prevents you from going to a ball game of your son's?
No, but they do regulate, like, if you take off FMLA and you're at the beach and you're running around doing things you shouldn't be doing, they monitor that and you can get in trouble for that from CSX. So I can't just take off FMLA and go, I don't know, go play volleyball or something like that, but I can go to a game or
I mean, physically, could you play volleyball anyways?
probably not.
And tell me what the rigors, the difficulties of your job are with your medical circumstances.
Well, with my arm, when I'm a conductor, I have to sometimes tie 40, 50 handbrakes with your arm, the metal wheels, they call it. You gotta use your arm. And that's how I hurt my arm when I had to take off. My arm popped and a ligament popped. So I was off for 4 months because of that. And I have with my back, when you're on a train a lot of times, you're bouncing back, bouncing a lot. So my back's goes out a lot. And then and climbing up and down the engine, on the engines coming off and down the cars. I mean, it's, your back goes out and I'm old now, so. But yeah, it's a lot, it's strenuous and it gets stressful too, like with blood pressure. A lot of times I come home, my blood pressure's 140 over 95.
I've got a text message up there. It's one of the first ones, I believe. No, strike that. I'm just gonna strike that, never mind. Did you, from the text messages that your wife sent you in early November, Did you feel like she was gonna try to get you fired over the FMLA stuff? Or get you in trouble?
Yeah, I thought she was trying to get me in trouble over it. Yeah, because she just kept on saying that, and I'm gonna get someone to call CSX and get you for taking off FMLA, and she used a lot of different things to try to scare me.
That's all, Judge.
Mr. Holly? Ms. Duke, Mr. Dunham, you may step down and have a seat by your lawyer.
All right, thank you.
Ms. Duke, you have any other witnesses?
No other witnesses, Judge.
Plaintiff or the movement has rested his proof. Mr. Holly, do you wish to offer proof? All right. Mrs. Dunham, if you'll come around, I'm going to ask you to raise your right hand and be placed under oath.
You will, let's start your name, state your name for the court.
Kara Dunham,
And Ms. Dunham, what's your address?
Sladenwood Road, Manlier.
Is that still the marital residence?
Yes.
Okay. You've had a chance to hear the testimony, and you had a chance to understand what he's testified to about how the paperwork got signed and whatnot, and you heard him say what he accuses you of doing. First off, did he see the paperwork before he signed it?
Yes.
When and how did that happen?
When he came over to Compassion
Duke,
Church,
you're going to have to move up to the microphone,
Sorry.
please, and try to speak directly into it.
that day that we went to Compassion Church, he came over. We were there for homeschool group. The kids were doing school. And he came over, we sat in his car, we went over all the paperwork, read everything out, looked at everything, and that's when he saw it.
So he had it there and he looked at every page?
We had it in between us, and I was reading it to him and going through, and he was sitting next to me and looking at it with me.
So when you're going through that paperwork, did y'all discuss changes?
Yes.
Okay, tell the court what y'all discussed about the changes and things.
The one thing he wasn't happy about was my spending budget. He thought that as long as he didn't have to pay that he could keep up with the rest of the agreement. And so I agreed to take that off.
Okay, so how much was that?
Well, my spending budget was usually $1,400, but I think in the paperwork we had it in even $1,500, I think. It
Okay.
was one or the other.
So you took $1,500 out totally?
Yeah.
And did that leave all the other expenses that we've talked about here today?
Yeah, he said he could keep up with everything else if that wasn't on there.
Yeah. And you agreed to take that off,
Yeah.
and then what'd you do next?
Well, the other thing was that I didn't think that he would agree to the travel ball hotel stays at all. And so I offered to pay half, and he came back and said, no, that's okay, I'll pay for the whole thing. So we left that. And then we talked about the Tuesdays. The Tuesdays was a day that he could most likely get off work every week. As long as he puts it in the schedule, he can get Tuesdays, because people don't usually take Tuesdays off at his work. And so we put that in there because he always said, oh, I can't get off on the weekend. So, so we left it at Tuesdays. And then, I'm sorry, what was the rest of the question?
Well, the question was about, what did you do next as far as the paperwork after
Oh,
you got done with the changes?
So when we
Have you
fin-
discussed all the changes? Let's make sure
Yeah,
we got that.
after we discussed the
Okay.
changes, he took the boys, I think they went to Walmart, and I went over to your office, and your secretary took that amount off of the paperwork, had me re-sign, notarize. And then I texted Michael and I said, hey, I'm leaving and I'll meet you at UPS. And then we met there. And I brought the whole packet in, and he said, okay, and he signed the whole thing.
Did he see the changes and look through that paperwork?
He didn't look through it, but I had it there.
Did he have all of them in his hand at one point to hand to her?
I don't know if he picked it up. It was in front of him, so I don't know that he put it in his hand, but it was right there. It was all together.
Or did you set it in front of him?
Yeah, yeah.
Okay. So when you were at the UPS store, were you all at one of those desks?
It was just the counter, at the counter. Yeah.
Okay. And how long did that episode at the UPS store for the notarization for Mr. Dunham, how long did that take?
It didn't take very long. I
Okay.
think we went out to eat together afterwards. So
Okay.
it was probably 5 or 10 minutes.
So what's your testimony about him having the paperwork at the UPS store? So I'm still a little unclear about that. Tell me what you did as far as him having the paperwork on his own, right there in front of him, that he could have looked
I mean,
at.
it was in front of him, and they had to open it up for him to sign it. And I mean, so he could have gone through it and seen if there was any other changes, but that was the only change. I had already signed, notarized, signed from your office the original, and the only change was that 1,500 that I did, so,
And that was at his request.
yeah.
And then after that, what happened? What'd you do next?
I think we went out to eat, went for Mexican, and then I don't remember.
His testimony about you influencing him or forcing him to sign it, twisting his arm, however you want to call it, you know, I think his testimony was, you know, he's not going to see the kids unless he signs it or a bunch, you know, some things like that. Explain your position to the court about that. Did you unduly influence him at all?
Yeah, I wasn't keeping him, you know, I didn't threaten that he had to sign that paperwork at all. We talked about all of the different details in there, and I was actually surprised that he didn't, you know, argue about the travel hotels and a couple other things. But he said, no, I want to make sure the kids are taken care of, and that you don't have to move. And so he said, okay.
So were you involved at all in any discussions with him about Ms. Roberts?
He said that he had an attorney that he had talked to, but before we signed, he said that he had fired her.
Why? Did he ever tell you why?
Well, he said that he was just going to go ahead and do the agreement with me, and so he fired her. He wasn't going to do that anymore.
Heard his testimony about him asking for money back from Ms. Roberts. Is that accurate? Were you aware that that was accurate? Were you involved with any of that discussions with him?
Yeah, because we talked about it, and he was upset that she wasn't listening to him, that she filed this paperwork after he told her not to, and he just felt that she, you know, she wasn't listening, so she should give the money back.
You heard him say that he didn't have any issues with Ms. Roberts.
You know, he called her a snake. He said she was mean. He, from what he was telling me, he was not happy with her.
Judge, I want to play just a brief recording between her and Mr. Dunham about that exact question.
Right.
Do you want me to plug in for all of this, or can I just play it with her right here?
Well, you can play it, put the microphone down where the speaker is on yours, and we'll see if we can hear it.
So I'm gonna play a recording and ask you, after you hear this, if you recognize this recording.
Fix this mattress and put it back so we can walk through. We're just gonna get the ball and go tomorrow in the morning.
Well, as she had a right to ask discovery, I would have provided it. If she wants to hear it, we'll
I'm
go
sorry?
ahead. I didn't get any discovery to provide this for her. If she wants to hear it, I'll be glad to take a break and play it for her. This is a conversation between Mr. Dunham and Mrs. Dunham, when he said he had no problem with Ms. Roberts at all. This is showing that he had a pretty serious problem with Ms. Roberts about the whole thing. Well, the date's not necessarily a paramount to a foundation. She testified that, well, I take that back. I was going to ask her some of these questions after she heard it, but if you want me to lay a foundation about her giving me this tape and what it is,
Not a
I'll be glad
question
to do
of what
that.
I want or don't want. It's a question of what's the proper procedure. Number one, the proper procedure would be to identify what it is that we're about to listen to and what the circumstances were and the time frame and so forth, so that Ms. Duke will be aware of how to, and this court will be aware of how this factors in and what we've been discussing. The other problem you're going to have is that I realize my hearing is not the best in the world, but it is not going to be very understandable for me to, unless you can plug in through the system and try to, which you certainly are able to do, but if you want to plug it in and play it over the speakers in the courtroom, that would be fine.
That's why that date is so, he's trying to say, oh, we never had a problem with her. No, we never had a problem after we found out her mother. That's why the date is so important.
That's what he testified to, is he never had a problem with Ms. Roberts. It was one of those situations that he never had a problem, is what I heard. His testimony was on direct examination, so.
Well, I'm going to allow him. Well, both of you are testifying now for your clients, and it might go quicker if you could just testify for your client. I realize, but the rules require them to testify. So, Ms. Duke, I'm going to allow him to play it. It would be a situation where he's going to need to establish the time frame of when this is before it's played, or let her listen to it and then have her identify when it took place. And then you can certainly cross-examine her regarding that. You can recall your client today or some other day when we're finishing this up. So, Mr. Hawley, you want to try to hook that up to the system?
What I am realizing is I have my laptop with me that doesn't have one of these connections. Well, wait a minute.
Either one of you guys know how to? My technical wizards are going to see what they can do to help you out.
Judge, if somebody's on their way or somebody's, I'll be glad to move on so we can keep going. We can play this later.
But
You want
if you want to move on,
All
we'll
right.
come back to it.
Did you ever stop him from seeing the children or hold that over his head to sign this paperwork?
No.
Can you explain to the court, what his pre-signing visitation kindly was and what it was after his visitation was after that? I mean, how was he getting to see the kids? How often, the duration?
We were kind of just working it out. He would, say, I'm going to be off, and then he would get the kids.
He testified that you
So-
threatened him in, I guess, a couple of ways. Did you ever threaten him about this paperwork?
No, I never forced him to sign this. I never told him he had to sign it at all.
Mr. Hollow, Officer Howell is here to save the day. You want to have your recording ready?
It's ready, plugged in and ready. I'll hit play. That may help the signal out. I may have started. Do you remember when this conversation was between you and Mr. Dunham regarding this ordeal with Ms. Roberts?
It was I believe the next week,
Thank you.
or within, days of us signing everything. It was right directly after everything had been signed, and
He show you how to do that? Sorry. You're ready to go.
So it was within a week after you signed the agreement?
yeah, I think he refers in there to dates. Well, I don't remember exact. But
You recorded this, correct?
yeah, I think he mentions a Tuesday, which would be that he talked to her, which is the day after we signed the paperwork. He
Okay.
mentions it in there.
So he would have already, or would he have already been through the issues about Ms. Roberts and not being able to get a hold of her and all of that stuff?
Yeah, this was after we signed everything, and he had been having those
Okay.
issues with her.
Again, I'm going to play this, and I want you to listen, intently to be able to answer the question, is this a conversation between you and Mr. Dunham?
I don't know if your dad's making money on those for you, sweetie. Let's just fix this mattress and put it back so you can walk through. We're just gonna get the ball and go tomorrow in the morning. I mean, we could just,
You turn the volume up any on your
we
computer?
could probably just drop it off tomorrow and then leave straight from there.
Drop what off, all the trash?
Yeah, in this mattress. Unless you're taking it, cause I need it out of here. I don't think so either, and it's got stains, cause that's who the stains.
Yeah.
I don't wanna, and it just is lumpy. Alright. Hey. Hello.
Well.
Guys, no fight though. I don't know what that means. I mean, I need to be able to take care of things. Michael, go. Okay.
And all of a sudden. But,
My phone's not.
if I can. Well, okay.
Well, I mean,
I can take off my credit card.
I mean, I have that coin I was gonna give you, but I didn't think you wanted to dip into that.
I don't know if I can get it, cause I mean, my check was, like you said, didn't work very much. I was kind of down and out, and that lawyer old deal, and I didn't expect to talk to you. And
Oh, shoot. Get through the door. Oh. They got the door open. Did Ethan go in there?
He's back out. Did she go back in?
No, she just went under these things.
Oh, no.
Buttercup. Okay, just go out and I'll shut the thing, but, I mean, so she's canceled. I don't have to.
See, that's another thing, I don't know. She's crazy. She told me I was speaking to Bill, and, I mean, she went off on me. And, said, you violated the client something agreement, and I gotta see that paperwork I'm putting on that lawyer and all that stuff. But she, I'll call you back. It's been a week at her, but I called her.
I thought you told her that I mean, you told told
I did.
me that you canceled her.
That's what I did, but I'm saying that's what she said. I don't know what happened. She ain't never called me back. It's been a week. That was last Tuesday.
Okay.
So I don't know what's going
Oh,
on.
there's the other one.
They were around.
Molly, you better get out of here.
But let me just, what I'll have to do is because I wasn't able to switch the deposit yet. Because it was just the other day. So I have to switch it the next time. But, so I have to just take cash down there Friday or whenever, Monday.
Okay,
whatever. But there's still,
are
there's
they,
there's $100 that goes in there still automatically. But I'll try to get $600 together and put it in. What were you gonna say?
well, I was just gonna say, we still need to go to that bank and get it fixed. That bank account.
Well, don't do I have to be honest with direct deposit?
No,
No.
no, but,
I can do that. I can go in town and take it off.
okay. But if you're gonna deposit cash, you probably need to be on this. You probably just need to deposit the cash. I don't know. I would just deposit the cash and then take yourself off after you deposit. You know what I mean?
All right. We'll just see how it goes. Let me know if you find that ball.
Okay, can you just watch and make sure the cats don't come out when I
Yeah,
turn
we
this
can
thing
share it.
on?
Okay.
I think the other one went in the house now.
I mean, that's it, if I can stop it, that's fine.
Molly,
Um,
I could not hear very well either, so he's introduced it, but as a trier of fact, I can assure you that it doesn't carry much weight with me because I could not understand it very well.
it's all digital, so I mean, I can only do what I can do with it and turn it up on this, and I can play it on this. We might be able to work on that. Let me ask you this question. In that conversation, I mean, when he said you heard him testify, he didn't have a problem with Ms. Roberts. Was that contradictory to y'all's conversation?
But say it again.
You heard him testify in direct examination that he didn't have a problem with Ms. Roberts.
Yeah, that's not true. He did.
So what was he referring to, Ms. Roberts, in this conversation?
That, sorry, I don't remember what he was upset that, that she just wasn't,
Was he calling her names?
yeah, I'm trying to remember what he said in that conversation. Because I know what he said other ones. Sorry, I was listening to that one, but I believe he said that she was mean, and that she yelled at him.
You heard him testify about he had problems with his elbow, and he's got problems with high blood pressure and things of that nature. Is that accurate?
Yeah, in 2020, I believe it is, that's where his pay is real low. That's when he had hurt his arm. That's when he first got the FMLA for his arm. And then he was trying to find a way to continue his FMLA after his arm was feeling better. So he started adding the other things on there to the doctor. But that was always an argument that we had about the FMLA, about him taking it for non-medical reasons.
And what was the basis of that argument, and what was the reasoning for that?
Well, because he would just take days off whenever he wanted to, and then I would say, hey, you need to go to work, and he'd say, well, I've made enough money this week. And then we would go to the end of the week to pay bills, and I'd say, hey, I need for this doctor's appointment or whatever it was. And then he'd say, well, I don't have that money, and you're just trying to get money out of me. I said, well, that's why you need to go to work. You can't just say, the house payment's done and then not go to work.
How long have you homeschooled your children?
For Michael and Ethan, the two boys that I have with Michael, they've always been homeschooled.
Was that agreement between two of you?
Yes,
Was that something that the two of you always wanted to happen?
yes,
You saw that text that we introduced in evidence you had about him saying didn't want the boys to be corrupted in public school and whatnot. Is that, or
Yes.
was that like a common conversation for the two of you to have and position?
yes, it was.
And how long did he pay for, or how long a period of time while you were married did he pay for the homeschool?
So really, the way that it was set up before the agreement, the homeschool group that I worked with, I would get enough, well, kind of. After my write-offs, I really didn't make any money, but I would use what was coming in on that and I would pay the homeschool tuition. But then when we made this agreement, he said he would go ahead and pay the tuition, but he wouldn't give me my budget money. But some of that, if I had any of that, then that would help me to make up, buying food and gas and all that.
The letter to Ms. Roberts, that termination letter, tell the court about how that got drafted and signed and whatnot.
So he wanted to try to get a refund from her. Plus, she had filed that paperwork that that had a court date on it. We didn't know what to do to get that off because he was telling me she wasn't listening. She wasn't taking it off the docket. He didn't know what to do. I said, I don't know either. I said, maybe if you, write her a letter because he was telling me that he had already fired her. I said, maybe you have to give her, a formal letter for her to get that off the docket. He said, okay. So I pulled up a template and I texted him. I said, hey, I've got a template. If you want to come over and write out what you want to write out to her, then, we can do that. And so he came over to the house and it got written out. We just worked together and then he signed it and it got sent to her, but then, yeah, it didn't come off the docket until that very morning of the court date.
Did he read that letter before he signed it?
Yes,
With you sitting there beside him, did he understand all of that?
yes.
I mean,
I
Diane, you'll lead
believed,
the witness, please.
yes,
I believed that he understood all of it because he told me his words, what he wanted to say and what happened.
can Mr. Dunham read and write?
Yes, he's an engineer.
Well, I'm just asking.
He has a two-year degree in college.
What college?
I think he went to one in Ohio.
Okay. So how often did you get paid for your homeschooling?
It's a commission, so it's just,
Well, let me rephrase that. Did you get paid every year throughout the marriage, pretty much?
from the time the kids started homeschooling, the year after that.
So
So he paid the first year.
tell the court about when you guys formulated the MDA and the spousal support was what, $1,400 a month, $1,500 a month? I'll rephrase. How much was the spousal support for the month?
Well, what we did is we talked about him giving me $1,500 every 2 weeks. And so then we took what was on the calculator for the child support and added to that to make it $1,500 every 2 weeks. So the spousal support came out to, I think, $825 every 2 weeks, so that he would be paying $1,500 for both.
How did y'all negotiate the 1,500? What was the reasoning for that?
Well,
Every 2 weeks?
he was saying that he would pay for everything except for my budget. And I said, you know, he was concerned about how much it was going to cost, trying to tell me, you know, well, I don't, you know, make but, you know, 4,000 or 5,000 a month. And I said, well, that's, you know, that's not true. And I said, well, if we take that off and we just make this number 1,500 every 2 weeks, would you agree to that? And he said, yes.
So what was the 1,500 in spousal support every 2 weeks going for?
So it was spousal and child support together.
Okay.
And the spousal was, you know, to pay for all the house expenses, you know, the mortgage, the utilities, any other expenses that I had, you know, the trash, the exterminators, all that.
How much is the monthly mortgage?
It was 2,400 then with the escrow, but I think it's 23 now.
At 2,300 a month, would the spousal support alone cover that?
No.
Where was the additional money coming from?
Child support and what money I can bring in.
And was it your responsibility to pay the mortgage payment?
Yes.
Okay. And your responsibility for the utilities and taxes as well?
Yes.
And that money was to come from where?
From the money he gave me.
Okay.
Yeah.
And was this something that the two of you negotiated in the drafting of your MDA and parenting plan?
Yes.
Is that the reason why you came about that figure?
Yes.
So had you stayed current on your mortgage to a point?
Yes, I was current for quite a while.
Yeah. And the boys live there with you?
Yes.
Are they homeschooled there with you?
Yes.
Okay. So it's their home and it's kind of their school as well. I'll
Sustained.
rephrase. So as far as the payments on the mortgage, did you get behind?
Yes, I did.
When did you start getting behind?
I think it was September.
And why was that?
He kept lowering how much he was paying every time. It would just, first he lowered it from 1,500 to 1,375, and he said, well, my lawyer told me that's all I have to pay. So then he paid that for a little bit, and then he lowered it to 1,000, and then he lowered it to 750, and now he's got it at 500.
With the obligations of homeschooling, et cetera, can you make the mortgage payments and all of that without the negotiated amount of money that's coming in your MDA and parenting plan?
I'm sorry.
I don't
I
think that's
don't
a
think that one was leading. He's asking, or he's prefacing the question or including in the question extraneous information, but it is not leading or suggestive of the answer. At least I'm going to overrule it anyway.
No, I cannot make the payments without the support that he sends.
So if that doesn't happen today, as far as that continuing, that gets modified today, what's the outcome of your position at home with the boys?
The house will go into foreclosure or it'll, you know, if it can be sold really fast.
So you talked about, or he did, I think he said like 170,000 in equity. Do you remember that?
Yeah.
That's what he testified to. Is that accurate?
No, it's
Why
not.
is that not accurate?
The house, we hadn't even been in the house a few months when we broke up. And when we discussed, well, it's not accurate because the houses in the area are going for the low or the high 300,000s. So there's no way that I could get, you know, what he's saying for that house. And they're comparable houses with the same builder, same amount of land, everything. The other thing is when we discussed the house, we, you know, had figured out that the 401ks in the house, by the time we sold it, did all that, they would be about even. So he was going to take the 401k, I was going to take the house, and then that way I wouldn't have to move. But at first he was upset about it because he said, well, the equity in the house is going to go up quicker than the 401k. And I said, well, I don't think that's going to happen, but we can talk about it some more if you think so. He said, well, I don't want you guys to have to move, so we'll just do it that way.
How much is owed on your home?
I think now it's 311. It's gone down.
How much equity would you testify to would be in the home?
You know, it really depends on what I could get for the house. I know the houses in the area are going for maybe 375, somewhere around there. I don't know if I could get a little bit more, but I'm not sure. They're pretty comparable.
You have to pay realtor and closing costs as well, correct?
Yeah.
And let's go back to the MDA, and you're familiar with the provisions about the 401K, correct?
Yeah.
And you heard the judges looking at it from his interpretation that, he would still have to pay spousal support and the 401K. Is that accurate?
No, in there it says payments because, first of all, he threatened to quit his job and go to Florida and run off. And I was worried about that. And that's why that provision was in there. Because I thought, he's run off from everybody else. I thought he was just going to take off and leave me and the kids, with nothing and not be able to pay the house. So that's supposed to be that if he gets behind, then I can get half the 401K, and that makes up the payments that he's supposed to have already made. And then it pays for future payments. But, say there's only 10,000 there, then just as an odd number, and, his spousal support is over that over time, then he would have to start making payments again, if that makes sense.
Was it ever your intention to have him pay spousal support and give you the 401K money?
No, that's why he kept the 401K.
And if you got the 401K money today, how much do you think it would be based on you living with him and knowing what's in his 401Ks?
I don't know because he's got more than one, and I lost access to the older ones like a long time ago, so I wasn't sure. And he's also taken those loans on the 401Ks recently. I think he had one loan that was almost paid off when we got divorced, but now he's taken other loans on it. So I don't know the numbers. I just know that we figured out the house and the 401K were about even at the time.
Did he get you heard his testimony about him having to call the police about the baseball cards. Can you describe that to the court, what happened?
Well, so what happened is he had gone across the road and he was staying at his mom's cabin. And he had, I don't know if he had all his baseball cards. He has over 20,000 regular cards. But then he has like signed, autographed Michael Jordan's, all that stuff. So he had it over there. I had the code to that. We were going back and forth, and I saw in our shared email that he had started to sell those off. And I was worried that we didn't have an agreement yet, and that he was just going to say, "Oh, well, I don't have anything. They're not worth anything. I don't know what you're talking about." So I went over there so that I could, take pictures of them. But I was kind of worried that he would get upset with me being there. So I went ahead and brought him back to the house. But before I could put him back, he sent me a text, and he was all mad, and he called the sheriff. So the sheriff came over. I said, "Look, it's marital property. I just want to log what it is." And they said, "Okay, well, do you mind, so we don't have an issue, do you mind just logging it? And then we'll take it back to him." I said, "Yeah, that's fine." So I took pictures of everything, and then I sent it back.
What's the, in your testimony, are these baseball cards marital property?
Yes, he bought all those while we were married. The ones he had before then were just like the dollar, or maybe $5. They weren't all the expensive, worth thousands and thousands of dollars. He didn't have that before we got married.
Did you call him names? Said you called him names. Did you call him names?
I told him a lot that he was, a liar. So if that's what he means.
Any other words, any other names?
Um, Manipulator. I don't really remember anything else.
Did he call you names?
Um, I'm not quite sure. He wasn't too nice to me. He would cuss at me a lot the last year. Um, threw trash in my face, things like that. But I don't remember him. I'm not quite sure if he really.
Can your kids read and write?
Yes.
Why is he saying they can't read and write?
I think Mikey has dyslexia, so it took him a very long time, our 11-year-old, it took him a very long time to learn to read. But he's been doing really good now. I mean, it just took him, but that was before we even divorced. So I think it's just an excuse that he's using because he's the one that wants to keep them out of school so he can take them any day, he wants to be off. And I'm the one that has argued with him, I need to be able to do school with them. So
How often do you homeschool them during the week?
well, right now he takes them on Tuesdays and takes them, he takes them on Monday nights and they get back on Tuesday nights. So they don't do school on Tuesdays because he doesn't bring them for school. So they do Monday, Wednesday, Thursday, and Friday.
What's been his participation in homeschooling?
When we were together, he would help them with the math. So he liked to do that with them. And then I would do the other stuff with them.
What is it now? since
I'm
you've
doing
divorced?
everything.
Do you give any reason why he doesn't do anything anymore with them?
We haven't had the communication, so I mean, he could do something with them, but I haven't heard from them that he's done anything with them. But
To be clear, have you held the kids hostage for money?
no,
When that was being implied during the signing of the agreement, what was his visitation then?
like I said, he would just say that he was off work, and then so I would just work with him. If I had something going on with the family, a special day, I'd say, hey, well, it's so-and-so's birthday. We would just work it out. We just worked it out,
About how many days a week was that?
I don't know. I didn't keep track. But I think with the agreement, I was really concerned about the FMLA. I didn't at the time want to put weekends, like every other weekend or something on there, because then I felt like it would force him to do something illegal. And so that's why we put the Tuesdays. But I didn't really keep track right then.
What's his current visitation been?
He's been getting them on Tuesdays.
Has he asked for any additional days?
He did message one day and say that he couldn't work and he wanted to get them a different day. But I had been advised by you to go by the plan, and so I just have been going by the plan.
While you were married, were you behind on any of the bills or any of the marital obligations?
No, we would always argue about money a lot, though, because he would go behind my back and get a loan, and he gambled and did a lot of other things. So we weren't behind, but we were always arguing about the money. Actually, you know what? Can I just thought, we did get behind with our old house when he hurt his arm. So we were behind then.
Did you kind of work your way out of that?
Yeah, he got a COVID thing so that the loan, it could be put on the end of the loan for the house.
You heard him testify, about his current, reduction in pay because of this. On average, what was he making while y'all were married?
Well, it's like I said, if he worked, he'd make a lot of money, but a
Well, you
lot
say a
of,
lot, how much?
well, 2023, he was at 100,000. And he had gotten a 4.5% raise that July, so it wasn't, it was only part of the year. Plus, he got a 4.5% raise this year from that. And that's with him taking 12 weeks of FMLA every year just to go to baseball games and do whatever he wanted.
You heard him testify that how he used the FMLA, was that accurate?
Oh, it's accurate that he just uses it whenever he wants to. It's not about his health all the time.
What did you see him use what reasons did you see him take FMLA for, if they weren't health reasons?
Days that he wanted off. And that's why he told me that he wanted to keep it, because that's the only way that all the guys in the railroad can get days off. Otherwise, they work you too much.
Oh, my question, what reasons while you were married to him, you
Yeah.
said he took 12 weeks. Was that all health related?
No.
Okay, what other reasons were there that he took FMLA?
It would be, one of the boys' birthdays. We would have family in town. He would take FMLA if we were going on vacation. He'd take FMLA for baseball tournaments. He actually got a letter from his company. He was in trouble because they saw that he was taking off like every weekend in a pattern. And so he had to kind of slow down on taking baseball weekends. He also would get a letter if he took any holidays off. And so he will not take holidays with FMLA because he knows he'll get in trouble.
Do you feel like this agreement is fair?
Yeah, I think so. He got thousands of dollars in baseball cards, and he got the 401k, and I got the house, and the other things are about the same as the cards, So I felt it was fair when we did it.
If that gets changed, or at least the monetary amount gets changed any way whatsoever, can you survive? How will you survive? Put it that way.
We'll have to, I don't even know, because we'll have to go stay with my parents, but they don't really have, well, we can't stay there very long, maybe, a couple weeks or something. And I really don't know what, if we had to redo everything.
How did you find out about his fiance?
Well, first I saw her car starting in July. So I knew he had.
Stayed.
Yes, sir. So do you know of any additional monies that he's spending for the fiance?
I'm not sure. She lives with him.
That's all I have.
All right, we're going to take our afternoon recess for 15 minutes.
rise.
Judge, I'm trying to be quick so we can get out of here, but Ms. Dunham, I'm Hillary Duke. So you agree to breaking and entering into his home and getting his baseball cards out, is that correct?
No,
Okay. Well, you went into his home uninvited, is that correct?
I had access to the place.
Okay, but you didn't have permission
I
to be
had
there, yes or
the
no?
code.
Did you have permission to be there?
I didn't talk to him that day before I
Okay.
went in.
So the answer to that question is no, I didn't have permission, is that correct?
We were married.
Okay. Did he give you express permission to be in his home, yes or no?
I did not talk to him
Yes.
before I went in.
Yes or no, and then you can explain yourself.
Can you ask it again?
Did he give you permission to be in his home on that date?
He gave me permission
Yes
to
or
go.
no?
Yes,
Okay. And on that date, you also took out of his home gold and silver. You had the majority of the gold at the house already, correct?
I did not. Can you ask one question? What was the first question?
You had the majority of the gold at your house already, is that correct?
I had all the gold.
Okay. And on that date, you took, aside from the baseball cards, you also took silver out of his home, is that correct?
No,
Okay. And you took ammo and his court documents out that day, correct?
no,
You took the copies of the court documents on that date that Ms. Roberts had drafted.
no.
Okay. And you knew what Ms. Roberts was wanting him to submit to the court on November the 7th.
No,
Got to be in the form of a question, Ms. Duke.
Okay. You knew, yes or no, the parenting plan that he wanted approved by the court was an equal shared parenting time. Yes or no?
are you asking me if, I don't know quite how you're asking this, because I did not know from any lawyer or any parenting plan.
On November the 7th, when you took documents from his home,
Oh, no, I did not.
Okay.
I did not know that, no.
you reviewed the copy of the documents that he received from Miss Roberts, correct?
No,
Said correct, it is a question.
She makes a statement, then she asks her a question at the end, so overruled.
And you testified earlier that you never knew about him hiring Miss Roberts until he signed off on the agreement with Mr. Hawley, is that correct?
no.
When did you know about Miss Roberts?
No. He had told me that he had a lawyer, but he said that he fired her. That's all I knew.
And I'm gonna go on, Judge, I think. At no point in time has he earned $120,000 in the last 10 years, has he?
In the last 10 years, no.
Okay. And you agree with me that your parenting plan shows that he was making $120,000 a year on the child support calculation? Yes or no?
Yes,
Okay. And that's not accurate, is it?
it was accurate when he signed it.
Have you researched the value of your home on Zillow or through a real estate agent?
I looked at there's two houses that just sold down the road from the same builder.
Okay. I asked you a specific question.
Okay.
Have you looked at Zillow or
I
spoken
did
to a
not
real
look
estate
at,
agent?
I did speak to a realtor. I did not look at Zillow.
Okay. Did you know that Zillow values your home at $493,000?
It's inaccurate.
Okay. And you've told this court today that this is a fair agreement because he got some things and you got some things, but you understand that you got a home, $7,000 a month from him. the trailer, the golf cart, the storage building, the gold. Can you explain to me how that's fair?
I say, okay, what was the beginning of your question? You're saying that I got,
You got the home,
okay.
you're getting
so-
$7,000 a month.
Okay, I did not get
You've got a
7,000 a month.
trailer, a golf cart, a storage building. Tell me how,
I don't get 7,000 a month. That's completely inaccurate. He's supposed to pay 1,500 every 2 weeks, and that's with child support. I don't get anything else. That was part of that. The trailer was a birthday present that I had gotten. He had never used that trailer. He doesn't know how to drive a trailer. That was mine. The storage building was part of the property. You know, the setup was so that I could do homeschool in there. He got thousands and thousands of baseball cards. He got all the guns. He left 2 rusty rifles and 1 handgun. So I basically got 1 handgun. He took all the valuable guns.
okay, those guns were attained before marriage, is that correct?
No, they were not. He did not have those.
And the
before.
baseball cards and collections were before marriage, is that correct?
No, only the cheap baseball cards that we weren't even talking about. These ones that are worth, 20, 30,000, whatever they are, those were all after we got married.
Okay, and you don't have any of that to show to the court today where you stole that book of cards and took your pictures? You don't have anything before this court today, do you?
I did not steal anything.
Okay. You took it, is that fair? You've already testified you took it. Yes or no?
I had
Yes
the
or no?
cards, and they went back to him.
Okay. But you removed them from his home without his permission. It's not been answered. It hasn't been answered.
Overruled.
You removed it without his permission.
I had
I
the
did
marital
is the answer to that.
property. Yes, I got the marital
Okay.
property, took pictures, and then they went back to him.
And you had multiple discussions with him about, I'm wanting you to have joint custody, but we're just gonna put Tuesday and then work with your schedule to give you more time.
No, he only gets 1 day off a week. So that was not a discussion.
Okay, but when he takes his FMLA, he might have more, is that correct?
If he takes days off FMLA,
Okay, and he's used his FMLA for 3 years in the marriage, 3 years. And now all of a sudden that you guys are getting divorced, you have some issue with how he uses his FMLA?
no, we argued about it all the time.
Oh, okay. You just don't like that you can't control when he's at work and not at work, is that correct?
Overruled.
You
can't control when he's at work and when he's not at work.
I told him, I don't care if you go to work or not, I just want you to make sure that you're providing for me and the kids the way that you've agreed, that's it.
And so on that list of items that I gave regarding the expenses, after he's paid you $6,776 a month, do you expect him to live off of $100 a month?
He doesn't pay that. That's not what he pays.
If my understanding is that, and I just want to make this clear because I know Mr. Duke, you continue to talk about that particular amount. My reading of the marital dissolution agreement is that he's going to pay her these monies, and out of that money, the spousal support, she is required to pay the mortgage for the house and the utilities. That's the way I read it. Is that not how you read it?
No, it says he's supposed to pay the utilities and the mortgage.
Well, let's look, just because I want to, this is a continuing issue that comes up. And All right, spousal support. The parties agree to acknowledge the husband shall pay to the wife the sum of $1,500 biweekly, and the payments shall begin on the first day of December 2023 for 3 months, and then shall pay $825 biweekly thereafter, and continue until the youngest child reaches the age of 18 and or graduates from high school, whichever is later, to which shall cover the cost of the mortgage, utilities, and taxes on the marital residence.
Yes,
Because-
but if you go down to the next page on 4, it says the husband shall be responsible for the mortgage payment, utilities, and taxes of the marital residence.
Where are you looking at that?
Page 4, sentence 1, 2, 3, 4, 5.
Husband shall be responsible for the mortgage payment, utilities, and taxes on the marital residence until such time as the wife can refinance the marital residence in her name only.
And the wife gets 10 years to refinance.
But
Page 6 of that is very plain, that what he's talking about on page, what the parties are talking about on page 4, with him required to pay the mortgage, utility, taxes, that's a spousal support going forward.
I
don't
understand
think-
that's the argument, but that's not clear.
I don't think anything in this agreement.
I'm sorry?
Well,
Clear what the course of I'm being required to interpret a marital dissolution agreement to determine whether it is one that is enforceable, and under the circumstances, all I'm pointing out is there's some confusion on whether or not, on how much it is that he is required to pay. Now, the language is contradictory in those 2 paragraphs in this marital dissolution agreement, is what I'm pointing out. In one, it says he's obligated to pay that. And then, as Ms. Duke points out, the next page or 2 pages later, it says that he has to pay the spousal support, and out of that, she'll pay the mortgage and so forth. So it's, those 2 are inconsistent in my opinion, but. Any redirect? Nothing? We have just a moment, I do have a question or two. In this message that was sent on November the 11th, 2 days before the signing of this agreement, it was made as exhibit number 6. You make the statement to him as following: I have piles and piles of evidence of your lies, and all that evidence can be backed up even more with subpoenas for your FMLA marked off days, personal vacation and everything. Then your work may open more investigations about your misuse of FMLA. There's a possibility of the judge referring your illegal jersey sales to investigators. Selling those to that store along with everyone else is highly illegal. I even showed you that guy that was arrested back when I was begging you to stop. You agreed to stop and never did. Please think about just working things out and stopping your illegal behavior along with the other stuff you're doing. Then it goes on to talk about the boys need a godly dad. Do you know what the term extortion is? All right, the term extortion means that when you are threatening someone with prosecution or criminal prosecution in order to gain an advantage in a civil action, that can be construed to be extortion. In other words, threatening someone to prosecute them or to reveal criminal conduct on their part in order to gain an advantage in a civil action is where this sounds a great deal like. So, and that was 2 days before he signed this agreement, correct?
Yes, can I comment on
Yes.
that? So when we were talking in that conversation, he kept trying to tell me that he only made $4,000 or $5,000 a month. And I said, you're lying about that. I know how much you make. So when I was talking about the FMLA and all that kind of stuff, I was referring to that. Look, it's all going to come out, how much you make, and we're going to know like that you are not going to work on purpose, illegally. And so then my thinking was that any judge looking at it would know that he's lying about his income, because he was trying to not, pay and not have to, support me and the kids because of the income thing. So that's what that was. And then I thought, okay, if we do have to go to court because of all that, then all this other stuff's going to come out, and I don't want him to lose his job. I don't want him to get in trouble.
But
So
all
I
of that
just
has
wanted
now
to do
come
an
out today,
agreement.
right?
Yeah,
All of
it's
that's
come out
now come
now.
out. Okay.
Yeah.
All right. Now, you drafted the template for the letter to terminate Ms. Roberts as his attorney, and I have reviewed that. Did you sign his name to that?
No, I did not.
So you're saying that's his signature?
Came to the house, and I even texted him. I said, I have a template. If you want to come over, you can look at it and, tell me what you want it to say, or we'll just work it out. And so he came over to the house. He said, what he wanted it to say. I fixed, made it sound professional for him. I said, is this it? He said, yes. He signed it, and that was it. So I just helped him with it.
Right. Well, and the reason I was wondering is after looking at his signature on that document and his signature on the marital dissolution agreement and his signature on the parenting plan, those signatures appeared to be different, and that's why I wanted to have you testify under oath as to who actually signed that document. So, all right. I think those are all my questions. Anybody have anything following up?
So, Judge talks about the paragraph in that text that, you were being a little forceful with him about laying out the reasoning and some of those things about the expenses and some of this stuff coming to light. So that was a couple of days before you guys signed on the 13th. And then on the 13th, when you guys signed this, when you negotiated the actual settlement, did you actually come way down on what you were asking for at that point?
Sustained, don't lead the witness.
What concessions did you make at that time on the 13th?
Oh, we took the $1,500 a month off.
Okay, and that was at his request?
Yes.
Okay. So did you hold all that stuff over his head when that was going on?
No, we didn't even discuss anything but the agreement.
Okay. And as far as that letter goes, did he ask for your help?
Yes, he asked for my help.
And again, he came over to your,
He came to my house.
Sustained, don't lead the witness.
where did he go to,
He came over to the house, and we sat at the dining table
okay. And again, that was at whose request?
at his request.
Mr. Duke, do you have any other questions? Thank you, ma'am. You may step down. Mr. Holly, you have any other proof?
I do not.
Any rebuttal proof? We'll hear you in argument.
Both parties had an opportunity to negotiate. We've heard that all day today. They negotiated. And just like any agreement, you go through points of negotiation with this and that. And it was negotiated. Both parties signed it. He had many, many chances to do other things. He did not. Fired his lawyer, see the termination letter, and he signed it. And again, this is, in my opinion, I think the evidence is clear, buyer's remorse. It's not $6,000, $7,000, it's $3,000. And you've heard that goes to the mortgage, utility expenses. If you want to, and you have the option of 60.02 to rearrange your order as well. So if that's something that needs to be rearranged, by all means, rearrange it. It's been the party's conduct this entire time. She wasn't taking this mortgage and getting hair and nails and eyelashes and all the things that we see people do. That wasn't what she was doing. She's paying the mortgage, testified she was behind when he got behind. And these two boys are depending on that for their homeschool and their actual residence at this point. She was the economically disadvantaged spouse throughout the process of the entire marriage. And that was what they had set up. That was how they did it. That was what they all agreed to, was the homeschool and that kind of thing. So the amount of expenses that were in that agreement, I would argue definitely not unconscionable. That's what they agreed to, and that's what she needed and what she had to have with a $2,200 mortgage. That's in evidence. 2,200 some odd dollar mortgage, plus the utilities. And the taxes are probably going to cover that 3,000. And that'd be my position. That pretty much covers the 3,000. Then all he's got to do is pay for the boys' extracurriculars and things of that nature. It wasn't her money. This was for the children. So I'm asking for you to leave everything the way it is. Again, if you want to rework that, where she definitely has to do the mortgage, utilities, taxes, and pay for it out of the spousal support, if that's unclear, then by all means, make that ruling. We don't have a problem with that, because that was the intention all along in those two paragraphs. But I appreciate your time today to hear it.
It's clear he had an attorney representing him at the time. Testimony was that the plaintiff in this case knew that he had an attorney representing him, and my client said that his attorney reached out to ask if service could be had. And Your Honor pointed out something that I'd pointed out early on direct, that she threatened him to sign this. It was absolutely extortion, and those were absolutely threats. He can't pay these amounts. The math is not mathing in this. It just isn't. He cannot live off the little bit of money that he has left at the end of the month. She takes some issue with FMLA. Well, she didn't take some issue with it for the 5 years they were married that he was on it. And lastly, and kind of one of the most important points, is that there's misrepresentations all over the place. The agreements, the parenting plan does not make sense. The MDA does not make sense. The parenting plan misstates what income he has. He never made $120,000, ever. But it has him as income at $120,000. The MDA is wrought with inaccuracies and contradictions all throughout it. I'd ask that these matters be set aside.
I know it's late. I'm going to take a short recess and review my notes before I come back and give you my ruling. We'll stand in recess for a short period. All right, ladies and gentlemen, I have considered all of the evidence in this case, and now we'll give you the benefit of my findings and conclusions. And this is a Rule 60.02 motion, which is made by Mr. Dunham in an effort to try to set aside the final decree and parenting plan that was entered in this case. Tennessee Code Annotated 364103 makes an affirmative obligation on this court to make sure that any approval of a marital dissolution agreement, for example, contains a finding or is a finding of this court that and I'm going to pull the statute up just to make sure that I'm quoting it correctly, but it requires this court to make an affirmative finding that the property division and so forth is all equitable. Let me refer you specifically to the statute. In an irreconcilable differences divorce, which is what this is, 364103 subsection B requires the following: no divorce shall be granted on the grounds of irreconcilable differences unless the court affirmatively finds in its decree that the parties have made adequate and sufficient provision for, by written agreement, for the custody and maintenance of any children of the marriage and for the equitable settlement of any property rights between the parties. If the court does not affirmatively find that the agreement is sufficient or equitable and the cause shall be continued by the court to allow further disposition by the petitioners. If both parties are present, then they can ratify any amendments and so forth. Problem here is that the issue that has been raised is that the marital dissolution agreement does not contain an equitable distribution of the settlement of the property rights of the parties. That's the allegation. The issues that this court finds to be present are as follows: that Mr. Denham was represented by counsel, Ms. Jennifer Roberts, at the time, and he, in fact, had retained her prior to any of the execution of these documents, that he was represented by counsel, and that fact was made known to Mrs. Dunham and her attorney, and that while he was represented by counsel, he could not reach his attorney due to her mother's serious health issues, and therefore he could not consult with her, but that nonetheless he was at that time represented by Ms. Roberts. During the time that he was represented by Ms. Roberts, Mrs. Dunham, as exhibited, as I've referred to in exhibit number A6, that was made an exhibit of a text message, that the court finds that Mrs. Dunham communicated to Mr. Dunham certain threats of possible criminal prosecution that would result if he continued to resist a settlement, and that those statements were made in an effort to coerce Mr. Dunham to agree to the terms of the agreement that she wanted. There was contradictory testimony in this case regarding whether or not she actually threatened to withhold visitation with the minor children, but there was also contradictory testimony as to whether or not he was presented with the entire agreement that was drafted by her, or whether he was given an opportunity to review the entire agreement, or whether it was just a signature page. He testified that it was just a signature page. She testified that it was the entire agreement. The court nonetheless finds that, despite that contradiction, that the marital dissolution agreement itself contains significant contradictory language regarding his financial obligations. That language is set forth in the agreement regarding his obligations about the mortgage that was brought up, that the husband on page 4 of the agreement, and in paragraph 4 of the agreement on page 4, it states the following: the husband shall be responsible for the mortgage payment, utilities, and taxes on the marital residence until such time as the wife can refinance the marital residence in her name only. The wife shall have up to 10 years to refinance the marital residence. That language requires Mr. Dunham to pay the mortgage and expenses, utilities, and taxes on that residence for up to a period of 10 years. That's the clear language that's set forth. In the following portions, under paragraph 6, the spousal support or alimony provisions, it states the following, that, and I'm going to skip on down rather than state that. It goes on to say that he will pay the $1,500, and I'm referring to paragraph 6 of the spousal support or alimony. He will pay $1,500 biweekly on the first day of December 2023 for 3 months, and then $825 biweekly thereafter, continue until the youngest child reaches the age of 18 and graduates from high school, the latter of which, whichever is the later, to which shall cover the cost of mortgage, utilities, and taxes on the marital residence. This court finds that that language, as Mr. Hawley and his client may want to try to interpret it, is contradictory to the language that was previously quoted. There's nothing in that language that this court can clearly see that that she was going to be obligated to use the payments that he was to make to cover the cost of insurance, cover the cost of the mortgage, utilities, and taxes on this marital residence. So I find that to be a contradiction that clearly creates problems for the marital dissolution agreement's enforcement. In addition to that, the court finds that the testimony and the proof before the court is that the marital dissolution, the parenting plan in the calculation of child support was based upon an income of $10,000 a month to Mr. Dunham, and that the proof has been that there was never any time during his employment that he made $10,000 a month. And therefore, that in and of itself constitutes a fatal error to the calculation of child support. Based upon all of those facts, the court is of the opinion that the equitable situation would be to consider the Rule 60 motion. And I would quote you the Beeson versus Beeson, which is a Tennessee Court of Appeals decision in 120 Southwest 3rd, 833. In that case, the court found that there was a Rule 60 motion to correct an error in a divorce in a qualified domestic relations order and a marital dissolution agreement in a case that awarded the wife more than what she was entitled to out of an award of a retirement account that the husband had, and that was a proper application of the Rule 60 to correct that error. This court is of the opinion that Rule 60 provides a relief in this case to Mr. Dunham, and therefore the court grants the Rule 60 motion that he has filed and sets aside the final decree of divorce, the marital dissolution agreement, and the parenting plan, and reinstates this case on the accurate document, on the active docket of the court. Ms. Newt will draw the order that reflects the court's ruling, and we'll send it to Mr. Hawley for his review and approval. That concludes our business for today. The court stands adjourned.